Okay, folks. I know we're on schedule, aren't we, Mr. Co-Chairman? We're on schedule. Okay, that's always good. I know that the Department of Health they're on a tight schedule, and I know they really want to weigh in. So what I'm thinking right now, I know it says LSO 0146 first, the Wyoming Data Privacy Act, which is one of our old drafts. We're going to do that one second. Let's go ahead and dive right into House Bill 163, data privacy government entities. Mr. Co-Chairman, you mind just giving us a little bit of background?
Yeah, Mr. Chairman, we had this legislation drafted last year during the interim, and you'll recall we had it passed for the legislative session, but then I believe it sat either not introduced or sitting on committee of the whole over in the House, but it basically wasn't worked through. So this is a piece of legislation that provides protections for data privacy for individuals in the state of Wyoming from the perspective of government data collections, and provides right to correct, right to delete, right to inspect, a lot of the kinds of concepts that help for good governance. But after we worked this bill, we ended up getting some feedback from some agencies that had concerns about the administration of the bill. So I think it'll be beneficial for us today to hear from those agencies, including the Department of Health, on what some of their concerns are with the language we have. And I do think that it's sensitive to the time that Department of Health has. Instead of going through the bill, we'll probably take their comments, and then maybe we go back and get Mr. Hopkinson to walk us through the bill. But I want to make sure that we have the opportunity to hear their time as well.
Yeah, Mr. Co-Chairman, I'm sensitive to that, and I think that makes sense. I know, obviously, as committee members know, usually it's talk about the bill, get testimony, all that kind of stuff. As long as the committee's okay with it, I have respect for the Department of Health's time. Maybe just have them jump right in.
Sounds good.
Don't was jumping out of their chairs. Do we have the Department of Health?
We do. Franz is right there.
Franz, there you are. Well, Franz, we'll let you just take it away from here.
Thank you, Mr. Chairman. Mr. Chairman Western, Chairman Rothfuss, members of the Blockchain Task Force. Sorry, a bit of an echo there. Happy to share my screen if you like, or let's see if that's possible with the permissions. Is that? Oh.
We're seeing it.
We're getting there.
Is that working?
Yes,
that's working.
We've got you.
All right, thank you. Well, again, gentlemen, I appreciate the lenience in giving us some with our schedule. I really apologize for the time conflicts we had. I would have loved to have joined you in person in Jackson, of course, but I'm afraid I have to settle for me over the Zoom. Just to get to the chase, this is our executive summaries in slide 2. We, when this bill came up last session, we submitted a fiscal note that may have been a bit histrionic, but we want to be constructive and recommend some possible changes to the bill that we feel would alleviate most of those concerns. So really, at the end of the day, we think that adding an explicit reference to HIPAA, the Federal Health Insurance Portability and Accountability Act, would be very helpful for us, as well as changing a 30-day timeline to 60 days. Those are our 2 top-line recommendations that we'd have. And you'll see on the next slide is kind of the red line version of that. The main concerns here, just in a nutshell, historically, the Department of Health, we operate under HIPAA. It's sort of been the governing statute for health insurance and health data privacy for pretty much everyone in the United States for some time, since the 90s. But the important point to mention is that HIPAA explicitly does not preempt more restrictive state laws. So if there were a state law that was passed that was more restrictive than HIPAA, we'd have to follow that. We couldn't say, oh, this federal preemption, we're just going to go with the federal law. And the real issue in the draft as written is that it requires the express written authorization for every single Department of Health client. And we don't see that being possible, frankly. So that brings us to some very interesting compliance issues, which we're not really sure what the magnitude would be or the cost would be, which is why the fiscal note had such large ranges. But at the end of the day, we see those consequences, as well as the administrative costs of changing the systems to accommodate that, being pretty onerous for us. So that's just in a nutshell. Moving on to slide 3, this kind of shows you the red line where we recommend putting in some changes. This really deals with purchasing, selling, trading, or transferring personal data without the express written consent of the natural person, and basically except as otherwise expressly prohibited by law, or as permitted or as required by the Health Insurance Portability and Accountability Act privacy rule. So that would allow us to kind of operate under the existing framework that we're very comfortable with. And then the second recommendation is under subsection C, just changing 30 days to 60 days. And that's really just a sort of an administrative issue. We have a certain staff and they have a certain workload, and shortening that timeline would require would have some administrative impact. It's doable. This is less of a serious concern than the first one, but it certainly would have an administrative impact on our privacy folks. So moving on to kind of some background now, that's, I could stop now and you get the nutshell version of what I'm about to say, but just some background. The Department of Health, we really are a big health insurance payer. We on the public side, to be fair, we don't collect premiums, and the revenue all comes from the dollars you appropriate. But it really is, it's a health benefit program for very low income and disabled people. You can see, roughly speaking, how many people are enrolled in our various programs. And really, we generally operate these like insurance plans. So there's a whole administrative machinery that enrolls people, that enrolls providers, processes claims, and so on, as well as deconflicting benefits with other payers. And that's kind of a significant point going forward, right? When we have other payers, say a private insurer is liable for certain costs. Say you have a Medicaid member who's in an auto accident and the other person had liability insurance, and that should be the primary payer for those medical costs. We need to coordinate with that insurance company to be able to ensure that the taxpayer dollars are conserved and used as a payer of last resort. That all requires the use and sharing of member data. We have numerous, probably 80 or so interfaces with various other agencies. We verify a lot of stuff electronically. So we verify citizenship, social security numbers, income, just on an enrollment side alone. And then, of course, there's data sharing with private entities, not just government agencies, but say insurance companies, to really verify their insurance coverage and whether or not we should be seeking reimbursement for third-party liability or avoiding costs, denying claims and saying, hey, go bill this other payer. That third-party liability function is pretty big in the health insurance for any health insurer, and it is for us. And then, of course, as a public payer, we are also subject to federal regulations, right? And the feds reimburse approximately 50% of all Medicaid costs, and as a consequence, if we're not in compliance with their regulations, they just won't send us that reimbursement check. That's a real possibility, right? I mean, it doesn't happen. I don't think it's ever really happened because we tried to maintain compliance. But at the end of the day, if we are not sending them what we've agreed to, the data we've agreed to, for example, that puts us in a situation where we may be risking some of those funds. And I just listed a couple examples there. There's obviously the Medicaid system, but also on our block grant for the behavioral health funds, we also have to report to the SAMHSA, the Substance Abuse and Mental Health Services Administration. We also require data retention. We retain records for a minimum of 7 to 10 years right now, and we do have records, claims data going back to 1993. And that historical data is really important for decision-making, obviously for recoveries, fraud, waste, and abuse, looking at state recovery, but also analysis. So you can see I had sent that link there. You can feel free to peruse that. But all that data is in that snapshot for enrollment cost trends comes from our claims data enrollment data that goes back for a long time. And then, of course, when we do large policy moves, for long-term care insurance or medical claims, we often will contract with actuarial firms, and we need to provide them with data to be able to do the modeling, right, to have the claims data to kind of make those future decision-making estimates. So retention is obviously very important for us as well.
Mr. Fuchs, let's just hang on for a sec. I think Mr. Co-Chairman has a question.
Yeah, Mr. Chairman, Mr. Fuchs, I wanted to ask a question on raising some of these concerns or how you use data. I feel like a lot, and I'm sensitive to some of the concerns that you have, but I feel like a lot of them were contemplated. And so my question on the trends in this long-term historical data you have, the definition of personal data we have in this act certainly implies that it's identified, and that you've got a name linked with the data, and that we certainly provide exceptions for research data where it's been de-identified and appropriately either aggregated or anonymized in a way that cannot be re-identified. It would be my assumption that almost everything that you have for your long-term data is probably going to fall into that category of exempted information. Is that fair?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair, most of the data in our claims and our records would be very identifiable and not de-identified. Those kind of extracts we might release on request if there was a research need from some outside organization. We could provide de-identified data, but all the claims data, it's enrollment data, it's radioactive with personal health information. I mean, it really is not that kind of de-identified research extract, which we would provide to some other entity for analysis, if that makes sense. But we don't think that this is a problem
Yeah.
with the existing statute, because the statute basically just says, if you have this, if you want a retention schedule longer than 3 years, you need to have a policy and a justification for it. And I think this is that anyways.
I guess I would ask though as a follow-up, and yes, it certainly has that. So you just have to have a written policy which says we're keeping it for this long for this reason. But I guess in that instance, I would ask the reason for having to have it be identified, and if a Wyomingite was interested in not having you maintain that record, what would you do if they said, I don't want you to have that any longer?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair, excellent question. I probably have to get back to you on that on our existing policy. I think we, as part of HIPAA, we are allowed to use this information, and they've consented to it in their enrollment form, right? As part of being a Medicaid member, I'm not sure they're allowed to say, I don't want my claims data in this data set. Because we've never, to my knowledge, ever done that. Why it's important is, I think, for example, say you're trying to model long-term care transition probabilities, right? Like we did with the PACE study. We're looking, saying, okay, this person came into the Medicaid program back in 1997 on the Medicare Savings Program. And these months they were in that program, then they switched to nursing home on this date and so on. And we're looking at factors like their age, their sex, any diagnosis they may have had. But also we want to know who that person, as an individual, that person's an individual, right? We want to make sure that we can distinguish all those claims records from everybody else. For the modeling purposes. So that's like kind of a reason why, when we're building these kind of claims models or transition models, why it's really important to have those demographic characteristics to be able to model the risk and say, so we can project forward and say, okay, for a 56-year-old person and on a Medicare Savings Program, a 56-year-old male, here's their probability of going to a waiver or nursing home, and kind of being able to extrapolate that based on our current client base. Long-winded answer, but we do use those personal identifiable details all the time in modeling. Those demographic characteristics are very, very important to retain.
Co-Chairman?
I'll stop there because I want to make sure he gets through all of his. I do have some follow-up questions, but I'll wait. Thank you.
Mr. Fuchs, please proceed.
So, Mr. Chairman, moving on to kind of, just some of the, what was already in the summary, we have very broad permissions for health plan operations. For treatment, payment, transfer of data. We don't require individual authorization. You can see the relevant CFRs there under the existing HIPAA privacy rule. And because HIPAA does not preempt a stricter state law, we would thus be required to obtain express written authorization from everybody for all data sharing activities, reduce our investigation response time from 60 days to 30 days, and have a default record retention period of 3 years. Again, as I noted, not a problem because we can justify that. But it's really the investigatory timeline, and more importantly, the express written authorization that's the issue that we have. And that's, at the end of the day, we just don't believe it's possible, right? There's a significant number of clients that are automatically eligible for Medicaid. So we receive, for example, information from the Social Security Administration that this person is on SSI, or a supplemental security income. There are foster care kids. There are ex parte renewals where we just are now required for a lot of low-income groups, where we just verify that someone's eligible based on an income feed that we have from Department of Workforce Services, for example. So in a lot of those scenarios, we are not actually having people fill out an application for Medicaid. They are automatically eligible due to state, federal law or policy. And so we do provide a notice of their data use and disclosures to all clients, but there's no, this person expressly consents, right? As required per the legislation to be on Medicaid. And so for this group of people, we're now going to be missing a substantial chunk of permissions, right, for those clients. And that creates we have to partition the data that is, been accepted or the client is accepted to it from the data that hasn't, and maybe not even have it. And then we have this whole issue of reporting to the feds and how it impacts our operations. So Really, the compliance with federal and data sharing requirements is the big ticket item here. We have to send 100% of our claims and eligibility to the Medicaid TMSIS system. And so, we have that ridiculous sort of fiscal estimate, less than or equal to $350 million per year. We don't know what that is. It's really unclear how the feds will react if we stop sending them data. But we'd certainly not be in compliance, and it certainly puts us at risk for something. We just don't know what it is. That's sort of the maximum exposure, right, for an annual, if we were to lose all our federal funding over this. And then there's
Mr.
obviously
Fuchs,
some.
Mr. Chairman, Mr. Fuchs, I think Senator Office has a question.
On that point, out of curiosity, are you required to include names and identifiers, or can so you have to explicitly include like their social security number? You can't de-identify that information as it's being sent.
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair, that's accurate. Yep. All that information is in their names, social security numbers, dates of birth. All of that is required.
Okay, thank you.
Mr. Fuchs, please continue.
So, Mr. Chairman, there's also some practical aspects of, third-party liability. If we are not able to, say, get someone's permission to share their data with insurance companies or look up how many, their assets. If someone goes to a nursing home, for example, our state Medicaid program attempts to recover people's assets when they pass away in order to pay back the funds they may have been expended for their long-term care. So those are just, again, less than or equal to $6 million for estate recovery and $27 million for TPL cost avoidance. Not very helpful numbers, I recognize. We just are very unsure as to what the impact would be if we were required to follow this. And then, of
Mr.
course,
Co-Chair?
A quick follow-up on that, Franz. When you share that information with third-party insurers, would they be legally allowed to take that information about patients and resell that in any way or reshare that in any way? How is that data bound on that share?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chairman, I don't know. I'll have to get back to you on that. I think most of the biggest use case here is we are getting information from insurers. So, a list of insureds and their plans. And so we can bounce it against our data and say, okay, this, Franz Fuchs is on Medicaid, but he also has Blue Cross, right? So that's the general use case for it, but I'd have to get back to you on the specific restrictions.
And Mr.
Co-Chairman.
Chairman, Franz, are you buying that from them?
Mr. Chairman, Mr. Co-Chair, we have statutory authority. I think it's 42.4 something in the Medicaid statutes regarding third-party liability. So they are required to comply with providing that information. But we are using, in almost all cases, using a vendor that works that kind of is in this business and works for a lot of other insurance companies in this coordination of benefits area. So it's typically through a vendor, but per that statutory authority, we aren't paying them. We are paying the vendor for the work, but we're not paying the insurance company for the data.
You are paying the vendor for the work. Okay, thank you.
Thank you, Mr. Co-Chairman. Mr. Fuchs, please continue.
So, Mr. Chairman, again, there's administrative costs here. So if we were required to, assuming the compliance issues weren't enough, modify all the interfaces we have to allow for this, explicit written permission. And you can see how many interfaces we have. There's also administrative costs, additional personnel. We estimated this at less than or equal to $10 million. Again, we just don't know the extent. We just kind of wanted to give the committee some awareness of the possible, maxima of the impact. And with that, Mr. Chairman, I'm happy to stop here and stand for any questions. I apologize. The square for you all is very small. So when I share my screen, that's better. So hopefully I can see if you have questions now.
Thank you, Mr. Fuchs. We had the slide posted to our material, so we've been kind of following through as you've been going along. Committee members, any questions for Mr. Fuchs or any discussion? Mr. Co-Chairman?
Yeah, Mr. Chairman. Thanks, Mr. Chairman. So a couple of quick questions. The first is, because of the breadth of the HIPAA allowances, you would feel that adding that HIPAA language would effectively cure all of the rest of the concerns because it does provide an explicit allowance through the federal statute. Is that correct?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair, that's correct.
Okay. And
Follow up, Mr. Co-Chairman?
yeah, Mr. Fuchs. When we look at the language on page 4, the paragraph A, that's the bit that you're amending, I just want to walk through a little bit about your concerns. As we contemplate, no government entity shall purchase, so you actually are purchasing at some point, as I understand, sell. I guess I would ask if you're ever selling data, trade, or transfer personal data. So let's pause there for a second. I see where you're purchasing in some instances. Are you selling data?
Mr. Fuchs?
Mr. Chairman, Mr. Cocher, no, we do not sell data. It's the purchase in some cases, but all mostly transferring. That is the
Mostly
operative
the
word.
transfer. Okay.
Mr.
And
Chairman?
thank you. So without the express written consent of the natural person is the concern. But we have this language, and I'm curious why it isn't sufficient, except as otherwise expressly provided by law. If there's no, I mean, that can certainly be read to incorporate HIPAA, but are you wanting more explicit permission that HIPAA is an allowance, a provision of law?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair. Yes, again, it's a kind of a conservative read there. I think part of the concern is that the HIPAA, it's a privacy rule. It's not necessarily statute, federal statute. And I don't know if that was the issue that was flagged by our council. But I think there's also an interplay, and I'd have to refer to my notes on this, and I apologize. I'll get back to you on this. As to the HIPAA has very explicit provisions about more restrictive state laws. So you have kind of these two provisions that may be pointing at each other. And I think
I see.
clarifying that it's HIPAA would govern in this particular case would be helpful for us.
I see. Okay. Now
Mr. Chairman?
Mr. Chairman, that helps, and I can see where that might be confusing and cause challenges. I don't see objections to anything down further on like the B and C provisions, which get to the right to inspect and right to correct. So there really aren't any concerns with that. I don't think you have those provisions in place now. You wouldn't necessarily have the right to inspect or correct. You were looking for 60 days, but overall, that's a doable thing that you currently aren't doing. Is that a fair assessment?
Mr. Fuchs?
Mr. Chairman, I believe so. The right to inspections, I think, is something that all Medicaid members would have a right to their health information, and to inspect that. I think the correction thing may be something we don't necessarily have a procedure for, but it's certainly doable. But we know we don't have any concerns on those provisions.
Mr. Co-Chairman?
Okay, and I think I'm good there, Mr. Chairman. Well, the last point, which we already hit on a bit, but I wanted to go back to, is the 3-year default and longer for the data records. And I guess this may actually be a public interest concern where you have effectively a policy that we're going to keep these records forever, and they're going to be identified because it's handy for us to model. And that's true. I don't disagree. It's always handy to have as much information as you can, and your model is going to be better if you have identification. But I guess the question would be, how much more limited would it be if you took some steps to de-identify to some degree? In other words, you improve the quality of it so that if it were hacked at some point, there at least wouldn't be a direct name associated. Maybe there's, as you do with clinical trials, you have an identifier that isn't a name, and then you typically store the identifier with a name somewhere else, and then at some point you might eliminate the identification file, and that's usually considered a better practice, although still not a best practice, because oftentimes you can re-identify. Have you had discussions about those types of data protection measures so that you can still maintain the veracity of your modeling, but maybe not be the great honeypot of health data?
Mr. Fuchs?
Mr. Chairman, Mr. Co-Chair, we have not. We certainly could try to estimate what that would take as far as changing our existing data warehouse and the protocols there. I'm sure it would be at some cost to do that. At the end of the day, however, there's certain standards for public health or personal health information, which even if you remove de-identifying information, if you have certain combinations of, and I'm sure this, dates of birth, places, to even the county location is very sensitive. So just combinations of cells like that also can make people subject to re-identification. But there's certainly things we could do to strip away identifiers and whatnot that would still make the data useful. I think it would be a cost to that.
Okay, thank
Mr.
you.
Co-Chairman?
I'm good with that. Thank you. I understand. Thank you, Mr. Fuchs.
Committee members, any additional question for Senator Ellis,
Thank you,
please?
Mr. Chairman, just a comment. I think Senator Roth has talked about page 4, paragraph A. Just as provided by law, if a federal agency delegates, if Congress in their statute delegates an agency to do a rulemaking, that does have the full effect of a law. So that's law that supersedes anything we could do. Maybe a way that we tackle that paragraph though, Mr. Chairman, is, we say that there are limitations on these transfers subject to the following exceptions, and then list them out one by one, because it starts getting a little clunky how we have it structured. And then we could maybe introduce a concept of having a special carve out for Department of Health and HIPAA compliance or something like that. But so I was wondering if Mr. Fuchs had a thought of, if that would add some clarity to his concern.
Mr. Fuchs?
Mr. Chairman, Senator Ellis, I think that would certainly work for us. It's again, I can't speak, I'm not an attorney, and I can't speak to how HIPAA, the privacy rule and its status as a rule, and it's explicitly saying that other state laws preempt or does not preempt other state laws and how they point at each other. I don't know how that all works, unfortunately, and I wish I had a lawyer here to talk to you more accurately about that, or in a clear way anyway. But I think what you proposed sounds just fine.
And follow up, Mr. Chairman.
Senator Ellis, please.
Thank you. And just kind of looking at that list, we are talking about a state government entity and their transfers, and we say that they can't transfer it to another governmental entity unless they comply with this article. And so maybe a question for you and for Senator Rothfuss is how we're contemplating when a state agency has to maybe provide information to some kind of federal agency. I'm also thinking about school districts. We have one Bureau of Indian Education, like would this, because it's so narrowly written from state agency to state agency, prohibit, a Fremont County School District from transferring it to a Bureau of Indian Education school because it's a federal entity and maybe they don't comply with this. So I just want to think through those unintended consequences. But I use that as an example to ask you, Mr. Fuchs, if there are instances where Wyoming Department of Health transfers specific data about people to a federal agency.
Mr. Fuchs?
Mr. Chairman, Senator Ellis, I think the biggest case is obviously working with our federal partners in the Centers for Medicare and Medicaid Services. We obviously owe them a significant amount of data. We transfer, the biggest source would be that TMSIS, the Transport Medicaid Statistical Information System. If I understand your question correctly, it's that was do we transfer to other federal partners?
Yes.
Senator Ellis?
Yes, Mr. Chairman.
Any follow-up? Committee members, any further questions for Mr. Fuchs? Maybe just the one I did have. Mr. Fuchs, what is the process right now if a Wyoming citizen does come forward and they want a right to inspect? What does that look like right now? I'm not sure, it probably doesn't happen too much, but if it does, how do you handle it and what's the protocol?
Mr. Chairman, I'm afraid I'll have to get back to you on that. I don't know the protocol exactly. Our Office of Privacy Security and Contracts would likely handle that in conjunction with Medicaid. I'm sure there's policy for it. I can get that to the committee.
Thank you, Mr. Fuchs. Any further questions? Seeing,
No, I was gonna say, I know he has to get to his meeting now.
yeah, Mr. Fuchs, again, we appreciate your time and just a thought out response to some of the concerns you have. So we'll make sure to take them into consideration.
Thank you, Mr. Chairman. And again, thanks for letting me testify remotely.
Committee, Mr. Co-Chair, maybe do we want Mr. Hopkinson to maybe do just a brief walkthrough?
Yeah.
Now that we're kind of
Refresh.
getting back in the order of operations here.
Right.
Mr. Hopkinson, you wouldn't mind?
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through House Bill 163, 2024 House Bill 163, Data Privacy Government Entities. Trying And then just to the first page, the first section that this creates a new Article 2. And then the first one is 921-201, providing for definitions. De-identified data, it talks about what that is. That's a definition we've debated a lot, I think, in the past with this committee. I want to highlight, though, the government entity number 2, because that one is, I think, kind of linchpin to what or who this specifically applies to, and it provides that government entity means the state and all its political subdivisions, agencies, instrumentalities, and institutions, and any local government entity. And government entity shall not include the judicial branch of government or any law enforcement agency in Wyoming. So we're explicitly carving out law enforcement and the judicial branch, and it only applies to state agencies. So when we say government entity, we're not talking about the federal government. Paragraph 3 provides the definition for identified or identifiable natural person. For law enforcement agency, I want to focus on this one for a moment because this also, I think, is critical to who this actually applies to. And that provides that it's a county, municipal, college, or university police force, the highway patrol, the Division of Criminal Investigation, Department of Corrections, or any state or local agency or political subdivision or part of any agency or political subdivision, to the extent that the primary purpose of the agency or political subdivision or part thereof is the prevention or investigation of crime and the enforcement of law. And then it specifically excludes the office of any city, county, or district attorney or other division of the attorney general, specifically referencing the Division of Criminal Investigation. So that would be the only part of the division attorney general's office that would be excluded. Personal data then is information that is linked or reasonably linkable to an identified or identifiable natural person, does not include de-identified data or publicly available information. And that publicly available information is information that is lawfully made available from federal, state, or local government records. Then jumping into kind of the meat of the bill and what it does, on page 4, 921-202, provides that no government entity, again, that's applying to the state government, shall purchase, sell, trade, or transfer personal data without the express written consent of the natural person, except as otherwise expressly provided by law, and except that a government entity may transfer personal data to another government entity, provided that the other government entity complies with this article. B starts getting into kind of the rights that the resident would have. It allows for a Wyoming resident to request a copy of their personal data and allows the agency to charge a fee consistent with the Public Records Act. C provides that a Wyoming resident who objects to the accuracy, completeness, etc. of their data or denial of access to it may file an objection with the government entity that maintains the data and requires the government entity to respond within 30 days, that they must investigate the validity of the objection. If the objection is found to be meritorious, they would alter the contents or methods for holding or the dissemination or use of the personal data or delete or grant access to it. Or if the objection is found to lack merit, they provide the resident the opportunity to have a statement in the file reflecting their views and disseminated with that data. And then they must notify the resident in writing their decision regarding the resident's objection. D on the top of page 6 basically carves out that if there's any other law that would be applicable to the extent that it conflicts with this law, the other law would control. Then in section 2, it creates 921-203, providing for the personal data collection and retention by government entities, and requires that in addition to the policies required under 921-101, which is just the general data policies that were passed 5-10 years ago, but are existing, that in addition to those policies, each government entity that collects or retains personal data shall adopt a policy regarding the collection, access, or retention and use of the personal data consistent with all applicable federal, state laws, and including this article. No government entity shall collect or maintain more personal data than is reasonably less necessary. So this is just a limit on what they can collect. They can only collect what they need to actually perform their duties. And they have to have a predefined purpose for that collection. No government entity shall maintain personal data for longer than 3 years without an express written policy identifying why they need that extension period and a reasonable justification. And then section 3, 4, 5, and 6 are just different timelines for when this would become applicable to various government entities. First of all, these dates obviously would need to change, but by January, the state chief information officer, would adopt or provide for sample policies. By July, each state agency would adopt any necessary policies and procedures for the state agencies. A year later, the county, cities, or towns, and a year after that, the remaining political subdivisions of the state. And then section 7 there just provides for a split effective date when each of those would come into effect. And with that, I'd stand for any questions.
Thank you, Mr. Hopkinson. Committee members, any questions? Seeing none. Thank you very much.
Thanks, David.
Thank you, David. Obviously, we've got state agencies, we've got Department of Health out of the way, but is there any other, we've got a couple, don't we? Who's on, we've got the state archives.
We do, Mr. Chairman. We have Sarah Davis. She's the state archivist.
Ms.
online.
Davis, thank you very much for coming. I will admit, this is the first be interacting with you from the Blockchain Select Committee, so we're glad you're here. Please go ahead and introduce yourself and take us away.
Thank you so much, Mr. Chair and the committee, for allowing me this time to talk a little bit about this bill a little bit. I think the mission of the Wyoming State Archives is actually to provide long-term preservation and access to essential records of state government, which includes permanent and vital records from state and local government agencies. And this includes agencies varying from the Department of Health all the way to local school districts. My major concern with this is that we do transfer regularly records of from other agencies into our permanent archives. And this is how we maintain being able to provide information to these everyday people here. For example, our highest request is for high school transcripts. And if we aren't able to take in those records and provide access to these citizens, their own transcripts, they will not be able to continue and on in their education or get jobs or just live their everyday life. We also take in court records. We are the house of the most court records in the state. It could be a tremendous impact on the courts if we do not house those records for them. We just transfer a lot of records in general is what I would like to say. And we store them in a variety of different ways. We store them in paper format, of course, but we also have what is called the Wyoming Digital Archives, which was created about 10 to 11 years ago to house digital records for state agencies in a secure manner. So one of my major concerns is we are tasked to keep these records for a certain amount of time, according to state statutes and laws and government. And we do facilitate the records management unit and state records retention schedules for the state. And the first issue I see is on page 7, lines 2 through 3. It talks about 3 years retention for these records. And most records do have a retention period that lasts longer than 3 years. And all the schedules can be found online on our website if you would like to go through that a little bit further. The second is that if the agencies do want to transfer their records to us, they have to have an exemption. And I think just in general, I would say by law, they are required to transfer some of these records to us. But putting up obstacles to have them transfer their records to us may actually cause in the destruction of records before their time period. This will, of course, have a tremendous impact on the state archives. In general, we've included a fiscal note in the administrative section. We do see that it will increase the amount of records that are being transferred to the archives, as well as the amount of data that's being requested from the archives in general. We have requested more people to be able to reasonably handle some of these requests, but we do have timelines that we have to meet to fulfill requests, and this could be a great challenge. So that's just the tip of the iceberg. I just wanted to share with you today, and I'd welcome any questions that you might have. And thank you for your time.
Thank you, Ms. Davis. Thank you, Ms. Davis, for sharing some of your concerns. One question is I did have was that I appreciate, you know, how you're worried about this, but on page 7, you referenced paragraph C, talking about the 3 years, but my question is, would the balance of that sentence take care of your concerns? So it reads, no government entity like the archives shall maintain personal data for longer than 3 years without an express written policy identifying the extended retention period and providing a reasonable justification for that period. So if you guys just simply just promulgated a policy saying, hey, as a matter of fact, we need to retain them for a much longer period of time because of the reasons you mentioned, do you think that would give you the flexibility to fulfill your obligations, or what are your thoughts on the balance of section C?
Mr. Chairman, thank you for your question. I believe that as it reads today, the exception is only can be interpreted as only the state archives has to put in an exception, but in all actuality, it would be all agencies would have to put in an exception. The records retention schedules actually apply to all state agencies, not just the state archives. And local municipalities and governments.
Sure. Ms. Davis, could they also not just, could all the agencies that you mentioned also just promulgate a policy saying, you know, we're gonna, come up with a policy outside of the parameters of what paragraph C is talking about? Could they not also do that as well?
Mr. Chairman, thank you for your question. Yes, they can do that, but that you would be receiving policies from all agencies and local governments.
Mr. Co-Chairman?
Thank you, Mr. Chairman. I guess the first thing I'd ask is just following up on the last question, what's the downside of agencies justifying all of their data retention, even if they're housing it at the archives? I mean, that honestly, that does seem like that's the intent here. So what's the concern?
Ms. Davis?
Sure, Mr. Chairman. Thank you so much for your question. I would say one of the major issues that we have with agencies in general is maintaining records for the appropriate amount of time and transferring those records to the state archives. Although we are very transparent and offer a lot of training on how long records should be kept, implementing additional obstacles for these state agencies and local governments to be able to keep their records for the appropriate amount of time will prohibit them prevent them from following these regulations and rules.
Mr. Co-Chairman, follow up?
Yeah, Mr. Chairman, I guess I'm not following that. So you have agencies and other state entities that you work with, and each of those that uses you as the long-term repository for certain data that they have, works within schedules that you recommend effectively for certain types of data. Is that accurate?
Ms. Davis?
Mr. Chairman, that is an accurate statement. The state of Wyoming has approved records retention schedules for all state agencies. They are not recommendations. They are what we are required to keep for a certain amount of time. The retention schedules tell you how long you must keep records. If you need to alter the schedule to meet some kind of need, or if laws across the federal government have changed, then you need to put in petition to the State Records Committee to alter that timeline or for evaluation, and the State Records Committee approves or denies your request based on their expertise and knowledge. With that said, to go back to your question, I think that agencies that do reach out to us do follow the guidelines, but there are certain agencies that do not follow the guidelines at all. So I see from my experience working at the state and with different types of levels of government, they do not want to, these agencies and representatives do not want to keep and maintain records or have to do extra work to maintain these records. Creating more obstacles does prohibit people from following rules and regulations. So the 3 years, although it would seem reasonable that they could put in a policy to ask for justification, you are going to get over 100 people, 100 agencies across the state sending you a policy requesting the extension period. So it doesn't even, it's not a valid, with all due respect, it is not a valid paragraph in general because no retention schedule is 3 years. That's what I'm getting at.
Mr. Chairman, is every single piece of data that is collected by all government entities in the state of Wyoming subject to those retention policies that are in place? So they have to keep absolutely everything?
Ms. Davis?
Mr. Chairman, that is correct. Every single piece of data is subject to the retention schedules approved by the state of Wyoming.
Mr. Co-Chairman?
Okay, Mr. Chairman, so if an agency buys a data set for marketing purposes so that they can send out information about programs, and they've effectively purchased it from a third party, there's no statutory requirement to do that, but that's something they make a decision about internally. They would need to send that data set that they purchased to the archives for long-term storage pursuant to the retention schedule that you work with?
Ms. Davis?
Mr. Chairman, thank you. That's a really good question. The retention schedules tell you how long you need to keep data for a minimum amount of time. Not all records are permanent, but there is a certain amount of time that records must be kept, and they can vary from 5 to 99-year records. So if the agency chooses or elects not to send or transfer those records to us, they are still required to keep those records for the appropriate amount of time as outlined in the records retention schedules, whether that be 5 years or 99 years, and maintain them in a format that is accessible for the entire period.
So, Mr. Chairman, thanks.
Mr. Co-Chairman?
And that's helpful. So the minimum's 5 years. So if I go into a county clerk's office and have any interaction with them where my name is included, for example, that interaction has to be kept by the county clerk's office for 5 years, and they have no authority to get rid of that interaction before 5 years based on the retention schedule. That's how it's currently structured.
Ms.
Mr.
Davis?
Chairman, it depends on what kind of interaction you're trying to, what is the function of that interaction depends on how long you are required to keep that piece of record.
But a minimum of 5 years. So that's what you said was the
I'm
lowest
assuming
possible.
it's 5
Mr. Davis.
years, yes.
Okay, so
Mr. Co-Chairman.
Mr. Chairman, so even if I wrote them a note, call me back later, my name is Chris Rothus. Here's my phone number. With a name and phone number, our rules and regulations, I assume the schedule is through rules and regulations and then statute enables that, would require that record be kept for 5 years, is your understanding, a minimum of, I mean, that might be a 99-year keeper.
Ms. Davis.
Mr. Chairman, records are kept according to their function of the request, the function of the actual record. We would look at the records retention schedule and see what type of record it is classified as to determine how long it needs to be kept.
Mr. Co-Chairman.
Yeah. So can you walk me through the record retention schedule, where statutorily that is enabled and how it is created and implemented?
Ms. Davis.
Sure. Thank you for your question. The Wyoming State Archives and Wyoming State Statutes 9-2-401 through 419 describes the functions of the Wyoming State Archives.
Mr. Co-Chairman, follow.
Yeah, please proceed if you have. I wanted to kind of understand the process. I can look up those statutes right now, but if you could walk me through the concept then of how and maybe it's all spelled out there. Is it all spelled out in statute what the retention schedule is? That sounds more like a rule and regulation thing, but is it in statute?
Ms. Davis.
Mr. Chairman, the statutes are very much spell out what the authority is of the state archives, and it even spells out the State Records Committee. The records retention schedules are tied to that, and they are available on the website for the Wyoming State Archives under government staff.
Mr. Co-Chairman.
Yep. Thank you, Mr. Chairman. So I guess I'll get to a couple of subpoints here. Does the state archives have a right to inspect and a right to correct currently available? So if you have data that you're storing about me, would I come to you to get that data corrected, or would I go or inspect it, or would I go to the agency that is storing it with you? I probably would go to the agency that's responsible for the data set, but how does that work?
Ms. Davis.
Sure. Mr. Chairman, the agency that owns the records creator, you will, if we have it in our possession, the records, then we will put you in contact with their records officer. If it is a record that is with the agency, you will still reach out to the records officer for that agency to examine the records. If the records are open to the public, I think this, we can just freely let you have access to that information. If the information is restricted, then you will have to work with the agency itself that recorded the, created the records. In addition, I would just say that we don't release information that unless it follows some of the state laws and policies. Our previous representative from the Department of Health talked about HIPAA laws. We are also worried about FERPA, and so we do not release transcripts to anybody but the student themselves. So the data, there's
Do they-
open data and there's closed data. And so we have a lot of policies internally about how we distribute information and make it available.
Thank you, Ms. Davis. Do you sell data sets at any point?
Mr. Chairman, we do not sell data sets at all.
Are you
The
legally allowed
records
to?
are available to the public for free. We do charge a minimum fee if we do have to certify that it is a valid record. And our charges are transparent and available on our website.
And do you, at any point, buy data sets? It doesn't seem like that's anything similar to your mission, or even transfer them to third parties. It would be you're acting as a storage repository. You're not acting as the entity that's really interacting with those records typically, or are you interacting with those records? I guess sometimes the request can come to you, but why is that, and when is that the case? Why wouldn't the request always go back through the entity that is responsible originally for the record? Is there something in statute that says that the responsibility goes to you in the archives?
Mr. Chairman, we do have more than one function in the state archives, and one of them is preserving the history of Wyoming. With that being said, we do have the archives, which are the permanent records of the state of Wyoming. That can include the Wyoming Constitution. It can include just general records about Wyoming history. And some of that is about lands and mining rights. And so we do interface with a lot of different patrons from a lot of different places. Some of this stuff is in digital, some of it's in physical format. And we do provide information to these people for research, scholarship, a variety of different reasons. We do get.
I'm sorry. Ms. Davis, I should have been more specific. My apologies. This legislation is really only about personal data. So I was specifically asking about personal data that's stored there, and I didn't make that clear. So with regard to agencies that store personal data with you, I'm curious what circumstances you would interact with personal data instead of the agency that's storing the personal data with you.
Yes, Mr. Chairman, the personal data can be found in all our records.
In all the records? I don't
In all
understand
the
that.
records, sir. Yes. You're talking about high school transcripts, you're talking about court cases, you're talking about type.
Or somebody muted. There we go. Now you're back. Please continue.
Everyone was muted. Someone muted everybody.
One second. Senator Ellis has a question. Go ahead.
Mr. Chairman, I feel like we're getting really off on this. I want to like really narrow in. We're concerned, and I don't want to speak for our co-chairman, but, information about your health, your social security number, your birth date, things that are used to threaten you. Certainly legal records, land records, that's public record. If you want to go look and see who owns a parcel, you can go look, that's a public document. So I just want to get us back to like what we're really concerned about is some of that sensitive information. I'm not worried about court documents. If it's in a court opinion, that's published publicly. So I just want to refocus you to think about what it is we're trying to protect here. And it's people's personal data, not, things that are in the public domain, such as ownership of land and things that being a human being in this world, if you're transacting business, certainly people are going to know that you're doing things and there are documents that support that. But just trying to get you to focus in on what you house that gets after some of those really innate privacy concerns. That's what we're trying to get after today.
Yeah, thank you, Senator Ellis. And on that point, it's specifically in the definition of personal data excludes publicly available information. So any record that would be a public record that you're holding, you can immediately mentally exclude. Anyway, and we did cut you off because of the mute. So please go ahead and continue based on that guidance from Senator Ellis.
Sure. Mr. Chairman, we do hold Social Security records. We do hold medical records. We do hold high school transcripts. We hold court records, and not all court records are open to the public and publicly accessible. So we do hold a lot of public, private information in the archives.
Great, thanks. Any follow-up, Senator? Go ahead.
Mr. Chairman, I think this legislation is in response to just an acknowledgement that, we live in a new era where information is, largely electronic. It can move pretty quickly. So we're just trying to provide some sideboards and protections for that. I think we all recognize the value of having some of these documents archived. I'm looking at your schedule right now. Is there a way we can make the legislation work? I mean, I feel like I'm hearing from you that we shouldn't advance this, but when I read the bill, I feel like there are some real simple solutions to make exceptions that address the concerns that you've been expressing to us. You talk about FERPA, certainly you can't just give out high school transcripts to anyone who asks for them, right? I mean, you've said this. I think that's all, those concepts are things, I think we're more aligned than you might think. So I guess what I'm asking is, do you have any suggestions of how to make this bill work to address your concerns? Because I think there's a lot of really good ideas in here too that aren't addressed in statute.
Ms. Davis,
Yes.
go ahead.
Yes, Mr. Chairman, thank you so much. I had previously submitted to the Data Governance Committee a request to change this paragraph to include, in accordance with the state of Wyoming approved records retention schedules instead of 3 years.
Senator Ellis, go ahead.
Thank you, Mr. Chairman. And I don't want to beat a dead horse, but I'm looking at the record retention schedule now. To me, this seems like a clear policy. I mean, if a member of the public wanted to see what is the record retention, they would look at this document and say, okay, and go through the list. And I'm reading it. It's a long document, 40 pages. So it seems like you already have a policy. So I just don't understand what I'm missing or what the concern is with this particular paragraph.
Ms. Davis, go ahead.
All right, thank you so much. The policy, and I can follow up with an email. But the policy as it reads as 3 years. Again, we go back to the first point I was already making regarding the records retention schedules applied to all of the state agencies and actually relate to all records produced by the state or received on behalf of the state. So again, most records have a retention period longer than 3 years. And so you will again receive exception requests from every single agency. So I am asking to change that language to just say in accordance with the records retention schedules as approved by the state.
Thank you, Ms. Davis. Leader Yin, go ahead.
Mr. Chairman, if I may, Ms. Davis, so I think that there's some confusion because you keep saying that we would get inundated with exception requests. But on the plain reading of the paragraph, and maybe I'm confused on how I'm reading this paragraph, there's no exception request process. You just have to have a written policy somewhere. It doesn't even say that the written policy has to be online or anywhere. It just says that the agency has to have a written policy. So even just if the agency had the retention schedule and said, our policy is to follow the record retention schedule, that would be enough to fulfill that clause, meaning that they would be allowed to maintain personal data for longer than that 3-year period. So there's no, in this bill, there's no process for granting an exception. An exception is just, you get the exception just by having the written policy. There's no submission, there's no roadblock in that regulatory framework. It's just, you just have to have the policy. And so if we just have to have the policy, does that still get in the way of agencies being able to retain that data as well as the state archives?
Ms. Davis.
Mr. Chairman, we just want to make sure that this bill addresses everything and doesn't require any extra work down the road. That's all I have to say.
Thank you, Ms. Davis. Any further questions for Ms. Davis? Seeing none, thank you, Ms. Davis. We appreciate your testimony.
Thank you.
All right, I believe we have one more interested in testifying, if I'm not mistaken.
Mr. Chairman, we have Ms. Edinburn with the Community College Commission. She's available to answer any questions on the memo they submitted.
Okay, well, let's bring her in and have her kind of give an overview for public edification of what her thoughts and concerns are, and we appreciate the memo. Ms. Edinburn?
Good afternoon, Chair and Committee. I'm Paris Eddie Byrne. I'm with the Wyoming Community College Commission. We did provide a memo to you to give you a little bit of insight of some of the ideas or thoughts or concerns that we may have regarding this bill. As you know, the colleges are considered government entities, so therefore they would have to comply with this as well. And there were some concerns wrapped around that, and inside the memo, we did provide a little bit of clarification around that. So in A of the bill, the purchase is specifically one that is of concern. The colleges do in fact purchase data, and that data is for marketing purposes, and they would like to continue to do that. That provides them with the ability to get students, as you guys can probably figure out. And then in addition to that, they purchase it typically from sources that have been given the permission to sell the data. So that's how they come about most of that data. Are there any questions regarding that concern?
Thank you, Ms. Edinburn. Select Committee, any questions? Ms. Edinburn, I think that actually hits upon one of the concerns that really has led to this legislation, was the idea of state entities buying and selling and transacting in data about people in the state of Wyoming. So we certainly do understand that it's an easy and great way to recruit, but I think it does call into question, you know, who sold the data to you and how did they get the data in the first place? And that, I think, is the inspiration for the creepy factor of where did that data come from, and why are we selling data about students in the state of Wyoming, even if we're selling it back to ourselves in some way? Do you know how that data tracked to you? Was it through one of the many exceptions in FERPA, which allows you to sell educational products and other such things? I don't know. I don't know how that took place.
Okay. Thank you, Mr. Chair. So let me clarify. This is the purchasing of the data, and typically it's purchased from places that you are very familiar with, anywhere from like Facebook, Meta, all of those places that you are the product, and by having that free thing, you are allowing them to sell your data. So they can do that, purchase that information from that source. I don't know the specific name of their vendors or anything like that. I can get that to you and get back, but that's kind of the idea about where they get some of that information, if that helps. They don't sell it.
Oh, it does. Yeah. So I mean, social media platform, that definitely makes good sense. Mr. Co-Chairman, welcome back. We're talking to Ms. Edinburn. If I have that, did I pronounce that right? Ms. Edinburn? That's correct, isn't it?
You absolutely. Yes, that's accurate.
Perfect. Thank you. We're talking with Ms. Edinburn from the colleges, from the College Commission. And they do buy data. They buy it from our social media platforms, who are always eager to sell.
They are extremely eager to sell, Mr. Co-Chairman. That's probably the most bothersome component
Right.
of this whole discussion.
And Ms. Edinburn, I like that you referred to the students as the product, because that's what I always tell my kids. If you're not the customer, you're the product.
That's how it works.
And yeah, they are the product. So Ms. Edinburn, I appreciate calling that out specifically, because that that really is what the A paragraph is getting at, is a discussion of, should we get that data? So we've purchased that data about students in the state of Wyoming. What do you contemplate is your retention schedule? We just had an interesting discussion with Ms. Davis. Is that, does that generate, you've purchased data about all of our students in the state of Wyoming from one of our social media platforms. You've generated a state record. Is that a public record?
Ms. Edburn, go ahead, please.
Chair, thank you. From the college perspective, not necessarily, they don't have to comply with the state archive, so that conversation prior to this doesn't affect that so much. But I know once they become a student, then they do have federal laws that they have to adhere to, which you guys have already spoken about. So that's not something that's a big concern to us. You guys already recognize that FERPA, HIPAA, all of those ones are ones that they have to recognize as well and work with. So I'm not sure I answered your question.
Well, prior to them
Mr.
becoming, Mr. Chairman, prior to them becoming a student, you've purchased a data set on students in the state of Wyoming, and you are a public institution. Why can't I query that data set and get all the information you scraped so that I can market to them?
Ms. Edburn, go ahead.
Thank you, Chair, Co-Chair. Well, FERPA prevents us, first of all, from sharing that data unless it follows an exception. And just getting the information is not one of them. Just because you want it, you have to follow certain exceptions in order to get that data.
I guess I would challenge that, Mr. Chairman, I guess I would challenge that data that you acquired from social media platforms is FERPA protected data, even if it's about the students. I don't know how it, and particularly if they're not even your students, if these are college age consumers effectively that are not students in your system, why can't I query that data set from you as a public record request?
Ms. Edstrom, go ahead. Edburn, pardon me.
That's okay, Co-Chair. Yes, so that specific question about querying the data that is not an actual student of the college and that has been a purchased one, I would have to ask the colleges to specifically speak to the availability of that data. But yeah, so I don't know the answer, but I can definitely ask them and get back to you.
Mr. Co-Chairman.
Yeah, one more. I guess I'm curious what your data retention and inspection and correction policies for that data set would be. So if I'm one of the students subject to that query file and I come to the College Commission and I say, I'd like to see the data that you have about me that's been purchased from social media, would you provide access to that? Would you allow it to be deleted or corrected? Or is that something that you would hold as a property right and maintain based on some policy?
Ms. Edburn.
Mr. Co-Chair, Chair and Co-Chair, thank you. So the commission themselves would not ever receive that specific data. We only receive data of once you become a student. So, and you have a record associated with being a student. The marketing data that's purchased does not come to us, so that would be held at the colleges themselves, and they would have policies around that.
Mr. Co-Chairman.
Yeah, I guess we just like, and you may not know, Ms. Edburn, what their inspection and retention policies would be like. I don't know if that's something you can comment on.
Ms. Edburn.
Chair, Co-Chair, no, I do not know what their specific policies are or procedures. I can get it for
Mr.
you.
Co-Chairman, follow up.
Great, that would be great. Thank you. No, I'm good there. Thank you. Appreciate your testimony. Thank you, Ms. Edburn.
Thank you very much, Ms. Edburn. We appreciate that. Is there any further questions for, let her go? Seeing none. Who else do we have for public testimony in the? Okay. Any other further public comment in the room or online before we close public comment? We'll go ahead and close public comment. I also just would really like to acknowledge a tip-top legislator, a dear friend of this select committee who thankfully has supported many of our bills over the years. That's Representative Andy Schwartz. Well, welcome to select committee.
Good to see you. I do recognize him.
Did you recognize him?
I did.
Oh, you did? Okay.
Right when he walked in.
You get double recognition. Committee, what's your pleasure?
Not necessarily moving now. We drafted for
I mean, I
next
think
time.
committees, or at least, is there any discussion, concerns? Senator Ellis?
Thank you, Mr. Chairman. I think on page 4, paragraph A, I think we can rework that a little bit to create a list of exceptions and maybe just to address some of the concerns we heard over testimony today. I think we do need to give a little bit more thought to making sure that agencies know that if they need to transfer data to a federal governmental entity or a tribal governmental entity, that we're not trying to get after those simply because we can't require like a tribal governmental entity to comply with this article. I think that's appropriate, but maybe if we just break those out, maybe that'll help provide some clarity with all this confusion. But I think this is an important bill. So I think it just needs a little more work, but hopefully we'll get some constructive feedback on it.
So Senator Ellis, in reference to the examples that you've made, is it including, for example, it says may transfer personal data to another government entity, provided that the other governmental entity complies with this article? Would the idea be including language, that complies with this article and other federal regulation? Is that kind of how you want to capture it, or what are you thinking?
No, I'm thinking, Mr. Chairman, that it would start out saying no governmental entity shall, purchase, sell, blah, 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 going on to line 10, provided by law, and then period. Exceptions to this paragraph are as follows. And then you have 1, the governmental entity may transfer personal data to another governmental entity, provided they comply with this article. 2, the governmental entity may transfer it to archives. I mean, that's where you can start really, I think, making it clear what, some of our exceptions are to address the FERPA, maybe the HIPAA concerns. I'm just trying to get us there because we heard a lot of confusion over this one paragraph, and I see it, but we could add some clarity to it.
Certainly, Senator. Obviously, this is the conceptual phase where we have this
Yeah.
dialogue. Mr. Co-Chairman?
Yeah,
Something
Mr.
like
Chairman, I think finding a way to call out those provisions and to make it clear that HIPAA allowances and FERPA allowances and transfers to federal entities pursuant to law, those types of things can provide exceptions. The one concern, and so I think we should do that. I absolutely agree with Senator Ellis. There are some concerns there. HIPAA and FERPA are not these ironclad great laws that really protect data privacy in an incredible way. FERPA in particular has massive carve-outs. If you provide educational services, you can effectively circumvent FERPA requirements, and then you're a third party that has received data sets, and then you can do things with those. So this idea that we're all protected because FERPA and HIPAA is out there, I don't think is accurate. So I guess that we probably want to provide the flexibility such that actions taken under HIPAA and FERPA can be implemented, but I guess we want to craft that language, the additional paragraphs, in such a way that it still minimizes it, and it's not carte blanche. Just because a behavior is open to HIPAA or FERPA doesn't mean you then get to just trade, buy, sell, anything else. So it's almost like the least restrictive format or least allowable, whatever the case may be. So I agree with Senator Ellis, though, calling it out certainly helps to address what we heard from the Department of Health and I think some of the educational concerns that I'm still creeped out by the social media data purchase. That's why we have this bill.
Mr. Co-Chairman, I am too.
On the other hand, I, for the life of me, do not believe that State Archives violates this bill as drafted in any way. I don't even think they'd have to take action.
Mr. Co-Chairman, I would agree that in paragraphs, yeah, I think it's expansive enough.
Yeah, so we can give
those
some, we
concerns.
can give some thought to that. At the same time, that I'm a little curious, and maybe we need to get some better testimony about the data records and retention policies that we happen to state, because they almost seem like they might preclude inspection, correction, and other things. I'm not sure. So that's the one concern I have is, are we running afoul from that standpoint where we currently have too restrictive retention policies that don't allow us to protect privacy as extensively as we might want to. So that
Hmm.
might need some further investigation. I
Yeah.
don't know the answer.
Mr. Co-Chairman, I think that makes a lot of sense. And, you know, since we're kind of spending time and hammering on the archives component, in the archives, there's a lot of information about Wyoming and the people of Wyoming in there. I think that right to correct
Yeah.
is really significant. I mean, you know, we can go down the rabbit hole with potential hypothetical examples, and I think that's important. Is there anything else from the committee members?
Mr. Chairman,
Representative Singh, go ahead.
thank you, Mr. Chairman. We heard testimony from the Department of Health that because of an agreement that we've made with the federal government, that we are then obligated to be sharing personal data, sensitive data with the federal government for a program that's designed to do good. I'm not suggesting otherwise, but I'm wondering how many other different agreements we are in with the federal government that require that type of agreement.
Yeah, it'd probably scare us to death to find that out. It's a good point.
I feel like that's that great scene where he's like, you can't handle the truth.
Yeah.
Um,
Mr. Chairman,
Mr. Co-Chairman?
I would add, like, changing the 30 days to 60 days. I don't see any problem with that. That's on page 5. If that makes a substantial difference to the Department of Health, I think they did a nice job of really thinking that through.
I think certainly makes sense. And I think Mr. Fuchs gave a pretty good justification for that.
And
Um,
Mr. Chairman,
Mr. Co-Chairman?
one thing that on page 7, no government entity shall maintain personal data for longer than 3 years without an express written policy. We could contemplate, I guess I have 2 comments here. We could contemplate changing that 3 years to 5 years, which is the minimum retention time that we currently have. So basically that would be, if you're not at the minimum retention time, you would have the question, why aren't you at the minimum retention time, right? Why do we need to keep this data longer than 5 years? And that would obviate the requirement for an explicit policy justification for most, presumably, of the things that would be in the archive at the default position. So I like 3 years better, but rather than trying to get the archives to change their records retention policy, maybe changing that to 5 years for default takes out, I don't know, hopefully like 90% of the retention time periods.
Sure. No, I think some consistency doesn't hurt.
Yeah,
At
so
least in this context.
let's change that to 5 years.
Any objections to that, committee? Okay.
And then the other thing I would say, which gets at, either you or Representative Yin said it, the idea about having to have the policy publicly available, because it was Representative Yin, I remember now, an express written policy identifying the extended retention period. It really should be a publicly available policy. So let's just add publicly available
Should be
to that
made
paragraph at
publicly-
some point.
Yeah.
So that everyone can see, just like the retention records that that we have at the state archives, that making sure that it's public as theirs is would be very helpful.
Yeah.
And then adjust the dates.
The other concern, Mr. Chairman, and I guess first, real quick, I know Department of Health also talked about, in that A paragraph in section 202, maybe we can just include that in the enumerations that Senator Ellis mentioned to incorporate the concerns of Department of Health. Mr. Co-Chairman, the other concern I had, and I thought about this, I don't know, some of the other folks know, but I'm a big sportsman, I'm a big hunter, and I'm a big public land hunter. That's one of my great pursuits. And I probably shouldn't say this on the record because I'm revealing proprietary secrets, but one of the things that sportsmen can do, for example, if they're looking to hunt on high quality private land, is what happens is some ranchers, some landowners, they, elk come in, graze down the natural grass that grows on their ranch. They can go to, the Game and Fish Department and seek damages, right? Which is fair. Kind of a little known trick that sometimes hunters can do is they can go down to the local Game and Fish office and say, hey, I would like to request a list of all the landowners that receive these damage payments, because in order for them to receive damage payments, they are technically required to allow the public to hunt on the land, of course, the theory being to help manage that herd. As I read the bill, I think that this would prevent or prohibit the Game and Fish Department from releasing that list. And so that's just something that's kind of concern to me. And I think, there's maybe a couple of different places that we can put some wording in there. But the scenario I want to avoid is that sportsmen who fund the department, fund those payments, are now all of a sudden being deprived an opportunity to do something and help manage those herds. So that's a thought that I did have. I'm not sure exactly how we could do it. There's a couple of ideas, but that's certainly a concern I think we might want to.
There is the express written consent aspect.
Right. But the department would have to specifically put that in their contracts which they could. I still think having some language in here, maybe we can work on it for next time, but that's something that's a concern that I have.
Mr. Chairman.
Representative Yen.
Yeah, if the damages, I mean, I think we just have to look at statute. If the damages require that the applicant's record be public in the statute, then it's already a public record and it's already exempt from that.
And my thought about that, Representative Yen, is, is it possible that the department could interpret it as conflicting statute? I guess that's more than anything. That's the worry there.
Well, this does explicitly defer page 6D.
So, I don't know if we want to work it in next time, but that's just a concern that I do have. I mean, I know we've got, what time is it? It's almost 3. So yeah, we've got some other stuff, but just keep in mind for next time. I'll be working on some amendments to it. Mr. Co-Chairman.
Thanks. One thing I'll note, which we hear a lot of, right? Privacy is ridiculously inconvenient for government. And here is where we're running into challenges. Everybody just says, but we want this data. We like this data. This is good for us. It lets us know things and we can do our job easier. That is all true. But it doesn't necessarily mean the public wants to give up its privacy to the government just because it's handy for the government to know everything about everyone all the time. And so I guess I'm sensitive to some of the concerns that have been raised about this will hold things back and it will make the government doing things that it wants to do a little bit harder. But, our job is not necessarily to find ways to make things easier for the government. Our job is also to protect the rights of all of our constituents. And I think they're feeling like their privacy is being taken a little too for granted. And we hear lots of examples of that. So it's in good shape. Hopefully we have more good discussion next time.
Is there any further discussion? So absent any objection, we're going to advance this on for further consideration at our next meeting. That's the objection.
Yeah, get it drafted up.
Excellent. Okay. Also, was there any clarifications that you needed, or do you think you got all of that?
Mr. Chairman, I think the only thing I'm a little unclear on was some of the suggestions from Senator Ellis. I don't know if that kind of fit in or if I was supposed to apply that portion of it. The rest of it seemed pretty straightforward, but.
Senator Ellis?
Mr. Chairman, I'm happy to work with LSO one-on-one if we wanted to take a look at that. And I think Senator Rothfuss gets it. This is a priority for you, and I'm trying to step away from some of this. So if you and I can work on it, or I'm happy to work on it, but.
I think as long as we can include, or Senator Ellis, as long as we can include, what the Department of Health talked about and some of that language change, I think there's nothing wrong with those enumerations. All right. Still on data privacy. Let's go ahead and we didn't specifically address the name, image and likeness, location data, express authorization.
Yeah,
Mr. Co-Chairman, I know we had talked about that in a lot of our discussions leading up to this committee meeting. Um, You know, in the interest of time, Mr. Co-Chairman, I thought is to maybe skip this particular one unless there was someone who wanted more.
we might have explicit, Mr. Chairman,
Or is it public comment? Yeah, Mr. Co-Chairman?
maybe I'd just say just a couple words on the thoughts there, and then we'll see if we have public comment that want to address it specifically. Well, I guess just overall data privacy we can go to after this, and you're right, going on to the next, but we have this legislation that addresses concepts related to government data privacy, but we really haven't taken action on privacy, which is more similar to the Colorado Privacy Act or our Wyoming Privacy Act that we tried to work through, where we're looking to protection from industry from the things like selling all of your data for social media platforms and trying to provide some protections for protection of your digital identity. There are some concepts here that other states have looked at, but nobody's really implemented that go a few steps further than what the CCPA and many of the other states have now implemented. And we have a list available in our meeting materials that shows where states are at with data privacy. It's a great little piece on 17-10 that we have, which is a legal tracker, and it shows all of the laws that have passed and all of the active bills that are out there, and we still haven't passed a law. So the concept is to try and find something where we at least provide some protections for Wyoming citizens of their privacy, and we can look to these legislation pieces and try and model after them. But the idea of the name, image, likeness, and the location data and expression authorization gets to some different ideas where I think it was Representative Yin, that sent the article about sale of tracking data, so your GPS data from your phones was sold and effectively stolen, and it was nobody knew that was even happening with your cell phones. Those types of protections just don't exist anywhere, and those are the types of protections we can look at protecting name, image, likeness type concepts. Own your data, own your likeness. That would go a lot farther than what other states have done, and really protect the individual's identity as opposed to just protecting your right to be a consumer in certain ways. That's the heavy lift that nobody's achieved, but we have a choice. Those probably aren't mutually exclusive. We could try and go down the path of looking to best practices in existing legislation from the consumer standpoint and try and implement something there. And then also maybe work on some other bills and legislation if folks are interested on these other areas. And I think we need to decide as a select committee what direction we want to go with that this year and how we want to prioritize that. We've got the government data privacy bill, but what do we want to accomplish during this interim on the broader data privacy discussion? And that's the one thing we should probably decide before moving on to our 3 o'clock topic is what does everyone want to do there? And we don't have anything here today, really. We've got some things to consider.
Committee members? Representative Yin.
Mr. Chairman, so I mean, I think at the very least, having some sort of liability. So, as someone who has a phone that has their data being sold and then finding out that it's being sold, that I have some sort of right of action to know that data has, to have some action to recover damages of me being tracked, being sold on the internet, whoever has money to buy it, right? So I think that there is some worthwhile thought to put behind that. And I don't know how broad we would want to make it, but I think that some liability would bring some better behavior.
So Representative Yin, you're imagining language that would put the actual, like the telecoms companies in a position of liability, or social media, or elaborate on that?
I think it would be anyone, any entity that sells your data, especially in mass like that, that allows you to be basically personally targeted by someone who buys that data, which could be any private entity. So,
We're a government entity.
so I think that I don't know if I have a very specific thought on how you would word that. But I do think that the liability has to be on the data broker, right? On the data seller, which in that case was the cell phone companies, the cell phone providers.
One thing.
Yeah, oh, go ahead, Mr.
Mr.
Co-Chairman.
Co-Chairman, one thing that we could do, which was kind of the concept here, is your location data could be deemed your property, right? We have control over property in Wyoming. We can declare your location data as your property. We could declare your likeness and your name as your property, your image, other data as your property. And that, you know, they cannot be taken or used without your express authorization. And express authorization we've used certainly doesn't include terms of service. So at that point, they've effectively stolen from you, and that gives you a cause of action. I think that would have some legal weight if we did it that way, and I think that's something that we could do in a way that would be effective and allowable. I guess I'd look to, I'd ask Mr. Kaufman if he thinks that would have legitimacy in practice.
Mr. Kaufman?
Yeah, Mr. Chairman, I mean, that's a tough one because there's a lot of different ways that could be assessed, you know, there's a lot of nuance to that, but yeah, I'm generally in agreement with your approach.
It's fun to talk about.
Yeah, Mr. Co-Chair, I mean, I think conceptually, we all know that this is huge, right? This is a battle that's been waging for a decade plus. I do think simpler is better, you know, because it's such a nuanced topic and all these different state regs and federal regs and agencies that I think if we can come up with an idea that's so simple, but so effective at the same time, I certainly feel better about that one, making it through the process and legal scrutiny than coming up with a, 40, 50, 60 page bill. Committee members, any? Representative Singh, go ahead.
Thank you, Mr. Chairman. I would like to make the distinction that this is a product that when folks are purchasing this data, unless it's like a very strange situation where someone is buying specific information about an individual, otherwise, like that would be weird, obviously, but this data is going to be collected in statistical pool and then to be purchased for best utilization by a business or a community college, and so that information within the context of statistical data gathering as compared to one's individual data, I just wanted to make a distinction that exists.
So, Mr. Chairman,
Representative Yang, go ahead.
the case that I'm talking about, I did send the link to the committee. If you click on Broke the News, I'll send the link as well. It details what the actual data broker was doing. You could literally put in a phone number and it would give you within 100 yards of where the phone currently is. And so it's not de-identified data. It is an actual individual's data that you could specifically target. So I think that's why they got fined, because it wasn't aggregated data of, this many people are in this location. It was an individual. You could search individual people's data at their current location in real time.
And the other side of that,
Co-Chairman.
Mr. Chairman, the name, image, likeness, and location data concept, these concepts about ownership of your data, ownership of your identity, even go into the aggregation. You think about what we were talking about with training artificial intelligence models and the interest of trying to have provenance in how the data that was used to train the models can be authenticated and attributed appropriately. Let's say that you are part of an aggregated data set. That was still you, that was still your actions that were a part of the aggregated data set that then might be sold. So how, do we want to account for that? That's nuanced at that point. It's not direct. It's an indirect economic implication, but it's still your data, so to speak, that is being used through a layer of abstraction. And that it's a point of discussion, right? It's just a level of how much ownership do we individually want of our data. That's probably a higher level of complexity that we want to start with, but it is something to potentially contemplate because we're now talking about it. It's a big deal over in the artificial intelligence space, right? That's huge in the AI space, but not even an afterthought at this point in the cell phone provider location data space. But I think it would be, this is something maybe what we can do is get a bill draft together on deeming name, image, likeness, and location data, and there might be other information there as components of a digital identity and as personal property. And also link back or call back to statute that would indicate that a misuse of that or without express authorized permissions, that's deemed theft. And at that point, that would get somebody's attention. What are your thoughts on that, Mr. Chairman?
Yeah, I think it's easy to identify the problem. Again, I think it really comes down to what can we do here and now. There's no doubt that the telecom, social media, all these kind of folks have absolutely been complicit. Know they've been complicit and haven't really done a whole lot, best I can tell. Not that I've followed them extremely closely. I think it's worth thinking about at the Apple. I really do. I mean, just given the urgency of it, the impact, and just how powerless the average folks are to combat these types of dynamics.
Well, let's try and get something drafted up on that. And honestly, probably still adding in maybe the self-sovereign digital identity concepts end up in a bill like that. Maybe they don't. It might fit. I mean, I'm just thinking about like the right to inspect and correct and things along those lines. If it's your property and someone else is using it, maybe you don't need that if it's your property. You have to have already provided the express authorization. It does get hard into, or becomes a challenge dealing with public use of name, image and likeness, and maybe we'd have to look at how that's crafted in laws that relate to name, image, and likeness of athletes and other places where that's actually being monetized. What is fair use? Clearly, that's going to come into play if I take a picture in the public. I'm going to have some rights to that. And that becomes a little bit challenging. If I know your location, for that matter. I mean, there's a difference, I guess, between location data that I'm collecting through the cell phone and, and I saw Afi at the grocery store a couple days ago, and I can attest to that. That's a different concept.
Senator Ellis?
Mr. Chairman, I think it's a similar concept. I think we need to figure
Yeah.
out why we're okay with one and not
Fair.
okay with the other.
Yep. Well said.
Mr. Hopkinson? Are you okay with a conceptual bill draft on this along these lines?
We'll have to working group that one, I think.
I think we'll probably need a working group, but just at a broad level.
Mr. Chairman, at a broad level, I think I'm okay. Honestly, my biggest concern with something as contemplated is I think there's a lot of unknowns at this point, which a working group would certainly, I think, be appropriate. You know, but potential issues with deeming something like that property. I don't know off the top of my head of any other place that has done something like that.
Nobody.
So that would certainly be unique and potentially raise some high level issues or concerns with doing it in that manner. But with the working group, we can do our best to get something put together.
Let's try and see what it does. Yeah.
I think so. I mean, we're, of course, if we're designated as property to be regulated by the state as personal property, that of course now enters the realm of all the rights, conveyances,
Yeah.
the dispute resolution that we currently have on the books, and if it truly is applicable, but might as well try.
Yeah. See what it looks like. I like it.
Yeah, for a working group, Mr. Hopkinson, let's maybe circle back in the next couple of days, get some folks. Mr. Co-Chairman, are you okay with being on that one?
Yeah.
Okay. Representative Yen?
Yeah. Afy, do you want to be on that?
Representative Yen is his 5 select committees that he's on, something like that?
All the committees. Let's get Mr. Kaufman too.
We'll put Affy on there and Mr. Kaufman as well.
Yeah.
Get a couple of lawyers on there. Mr. Co-Chairman, in the interest of time.
Let's be done with that.
Yeah,
Without
let's-
objection.
Yeah,
let's-
without
let's
objection.
that.
Is there any objection? Seeing none, let's just move on to the next
Do
topic.
you want a short break before we start?
So the next topic is
Afy
our
does too. Yeah.
is our cryptocurrency mining update. Obviously, there's been some pretty serious developments in the space, certainly in the last couple of weeks. But before we do that, let's just go ahead and take a really quick 10-minute break. It's 3:17. Let's just convene back here at 3:30. Excellent. Okay, we are back from a short break onto our final topic. As I mentioned before, crypto mining has had a bit of a roller coaster ride, like a lot of other things in the digital asset space these last couple of years. And certainly the last couple of weeks with the announcement from the executive order from the White House and the Sisyphus ruling. What we're thinking right now is maybe, Mr. Hopkinson, if you're okay, maybe just going over the executive order at a high level. But before we get into it, I do just want to say, to folks online or, folks you're here in the room, I know this is a very contentious topic. There's a lot of money at stake for people, their businesses, their livelihoods, employees, all that kind of stuff. So I just want to reemphasize some of the decorum. Keep it on the topic. Please avoid impugning the intent or the character of other members, or certainly just anyone else in the room on this topic. So let's just try to keep a lively but to the point discussion. So, Mr. Hopkinson, if you wouldn't mind walking us through the executive order.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office. Just taking a quick kind of high-level overview of the executive order from May 13th, 2024 regarding the acquisition of certain real property of Cheyenne Leads by Mine One Cloud Computing Investment, ILP. Essentially, the order kind of first makes some findings. It found that there was credible evidence that Mine One and its subsidiaries, affiliates, et cetera, majority owned by Chinese nationals, through the acquisition of property near Warren Air Force Base, may take action that threatens to impair the national security of the United States. And based on that, Mine One acquired the real estate in June 2022. They did not file that transaction with the Committee on Foreign Investment in the United States until there was a transaction, or the committee investigated as a result of a public tip. The executive order then basically prohibits that real estate transaction, gives Mine One 120 days to divest of all interests. They got 90 days to remove equipment and improvements on the property. And that they must immediately refrain from accessing the property except to effectuate the divestment and the removal of equipment and improvements on the property. Essentially, it prohibits them from doing anything to impede the transition of ownership. They have to certify on a weekly basis that they're compliant with this, and they certify in writing once it's all completed. And the committee is authorized to enforce the terms of the executive order and do inspections, things of that nature. So kind of broadly, that's basically what the executive order encompassed.
Thank you, Mr. Hopkinson. Committee members, any questions? Any questions? Before we open it up to testimony, is there any comments or considerations? I'll certainly say that it's kind of wild that a federal authority has the ability to, maybe not necessarily reverse, but to force people to sell their real property. But at the same time, I understand that this is a serious issue, and the security of some of our military installations is paramount. Mr. Co-Chairman, was there anything else? Any comments or before we open it up to testimony?
Mr. Chairman, I would just say, a couple things in my view. We've worked hard as a select committee to provide opportunities for cryptocurrency mining in the state of Wyoming, and to do that well and to create an ecosystem for that type of innovation to take place. So I'm hopeful that we can find a good solution to move forward. I don't want the industry to feel like Wyoming isn't receptive and welcoming of digital asset industry. And obviously we've put in a lot of work to get these people here, to get good projects to the state of Wyoming, and we'll see how this turns out. I know that we've got some good public testimony ahead, and I'm hopeful that we have a positive outcome from this.
Mr. Co-Chairman, I think that that's pretty accurate. Not to dig up old disputes, but I know we put a lot of time and energy, and unfortunately, kind of banged our head against the walls back. And if we recall back in, was it 2020, was it 21 that China banned crypto mining? And we saw the big rush. And I know this committee and Sharon, the co-chair, and I put a lot of effort in trying to get some of those folks here, and along with a lot of others. And I think it's important that, to the folks who aren't interested in following the law and state or federal, I'm sorry, but we don't want you here. But it's also really important that we send a really clear message to everyone who is here to play by the rules, state or otherwise, that we absolutely want your business. We want you here. We think that you have a lot of value add to the state, to the community, and we want you to be successful in Wyoming. And we're really committed to that. If there are any questions, is there anybody, members online from the committee who want to make questions or statements? Seeing none, let's go in-person testimony first, and then we've got some folks lined up online who have some comments they wanted to make, but was there anybody real quick in the room? Council Land?
Thank you, Mr. Chairman, members of the Select Committee. I'm just going to provide a couple of introductory comments and then be happy to stand for any questions about what happened in the executive order last week. Senator Lummis is very committed to making sure Bitcoin mining can grow and thrive in Wyoming and across the nation. There are a lot of things that kind of go into the discussion about Bitcoin mining in Wyoming. Utility rates are one, flared natural gas, real estate. So it's a complex issue, but Senator Lummis is very committed to working with each of you, the governor, and the industry in Wyoming to grow this sector. At the same time, she's also concerned about the malign influence of China in a lot of places in Wyoming and in the United States more broadly, not just in the Bitcoin mining sector, but in the ag sector especially too. So Senator Lummis's view is that we have to balance those two factors as well as we can. And Mr. Chairman, you said it exactly right. Like, if you're not complying with state or federal law, like, should you be in Wyoming? We're probably not a good fit. So that's my boss's view. President Biden did issue the executive order last week. We didn't have any advance notice that it was coming. It's not exactly unprecedented, but it's not normal practice either. There's only been a handful of these and none in the crypto space to this point. So we're monitoring it very carefully, and we've been trying to assist some Wyoming entities in making connections in Washington, D.C. that can be helpful, to their business moving forward. So anyone in the Bitcoin mining space that needs help, kind of bridging the gap between, their business operations and, what the Treasury Department may or may not do in the future in this space, I definitely encourage them to reach out to our office, and we can be helpful with making some contacts in Washington, D.C. that could be useful. So with that, I'll stand for any questions.
Thank you, Mr. Land. Committee, any questions? Mr. Land, we really appreciate obviously you worked incredibly diligently on this, and you can certainly recall the battles we fought trying to get them here.
Yep.
And certainly those frustrations with the utilities.
Yep.
They burn strong with this committee.
Yep.
Well,
Thank
you. Appreciate that.
Cool. All right. Thank you.
Thank you, Mr. Land. So we've got some folks online. Is Mr. Zach Bradford? Can you hear us okay?
Yes, I can.
Excellent. Mr. Bradford, I know you're a busy person, and I know this is a really big deal for you guys. So I really we appreciate you making time to come and testify to this committee. Just in terms of committee rules, just introduce yourself, who you are here on behalf of, and give us what you got. So go ahead, please.
Appreciate it. Good afternoon, committee members. I'm Zach Bradford. I am the CEO of CleanSpark, and that's who I'm here representing today. We are a publicly traded Bitcoin mining company listed on NASDAQ. Since taking the role as CEO in 2019, I have the privilege of leading a talented team dedicated to mining Bitcoin at scale. And before stepping into that role, I was the Chief Financial Officer since 2014. A little bit of background on CleanSpark. We were founded with a mission to advance energy solutions, particularly related to energy software and controls on distributed energy management systems. Since that time, we have honed our focus to Bitcoin mining, leveraging the expertise in energy solutions, and our goal is to deliver operations that are both efficient and environmentally responsible. CleanSpark stands out in the industry for its commitment to efficiency and operating at scale. Our strategic acquisition and expansion have solidified our position in the Bitcoin mining sector, and we're now one of the largest publicly traded Bitcoin mining companies in the country. We operate facilities in Georgia, Mississippi, and we co-locate mining servers in a partner in upstate New York. We just announced an acquisition here in Wyoming, and it would be our first data center in the Mountain West, although we are headquartered in Nevada. I grew up in Utah, and we have 2 board members who actually hail from Wyoming, one that still resides in the state. So recently, we announced an acquisition of 2 Bitcoin mining sites in Wyoming. This acquisition is a strategic move to expand our mining capacity and take advantage of Wyoming's favorable regulatory environment and abundant energy resources. The Wyoming sites will enhance our operational efficiency and contribute to our long-term growth strategy by increasing our mining capacity and reducing operational costs. This acquisition aligns with our commitment to sustainable growth, operational excellence, and being good neighbors in the communities we operate in. We make every effort to make a lasting impact on the communities we operate in, as is evident in both Georgia and Mississippi, where we have become important members of the rural communities, which is where our teams live and operate. And as you know, one of the sites in Wyoming that we announced our intention to acquire have recently become the subject of the presidential order. Now, we are currently working toward a timely and successful closing. We respect the oversight process, and we're dedicated to ensuring that our operations bolster national security and benefit economic development, particularly in Wyoming, a state that has been at the forefront of developing and nurturing a pro-Bitcoin environment. So the acquisition is currently under review by the Committee on Foreign Investments in the United States, and this review is a critical step to ensuring compliance with U.S. national security regulations, and getting our approval would be the only way to finalize the transaction. We remain confident in our ability to complete the acquisition and seamlessly integrate the Wyoming sites into our operation, which would represent a significant milestone in our growth journey and our commitment to realizing its full potential. Thank you for the opportunity to speak today, and I look forward to addressing any questions.
Thank you very much, Mr. Bradford, for your testimony. Committee members, any questions for Mr. Co-Chair?
Thank you, Mr. Chairman. Welcome, Mr. Bradford. We appreciate having you here. I was curious, you laid out a little bit of a timeline, but could you go a little into a little more detail about the timeline as you see it in terms of potential approval, the transaction window, and everything else associated with the acquisition?
Mr. Bradford, go ahead.
I don't have full specifics, but I can speak broadly to it, and it would require basically a 10-day approval process upon certain steps that are yet to take place, but we do intend to take those steps over the coming days. So at this point in time, I would say we will know and hear back from the Committee on Foreign Investment within the next 2 weeks.
Mr. Co-Chair, follow-up.
Great. Thank you, Mr. Chairman. So 2 weeks for that approval, and then does this, other than that approval, let's assume we get the approval and everything goes well, what is the rest of the timeline for the acquisition? Would this slow down the timeline that you may have already had in place, or what are the implications?
Mr. Bradford, go ahead.
One of the great unknowns is obviously the order requires the land to be cleared. And we were actually intending to acquire it with it being cleared. We were going to bring in our own infrastructure and equipment. A timeline that would be uncertain for us is how quickly they can actually clear the land, because if that is ultimately still required by the order before we take possession, we would have to wait for that to happen. So that fits within our timelines, but their inability to access the site is likely to slow down that process. So it does create an unknown for us, and that of course does affect our ability to move in and, purchase energy and, have the economic impact we desire.
Mr. Co-Chairman Paulo?
No, that's good. That's what I need.
Mr. Bradford, so just to maybe help give me a point of reference here. So you guys were looking to expand into the area. Obviously, this whole dispute went down. CFIUS came in, obviously, is doing a forced sale within that 120-day window. Is that where you entered the picture, or were you looking to acquire this before CFIUS got involved?
We were unaware of the order and actually entered into a definitive agreement to purchase both properties a week before the CFIUS got involved. We found out in the same way I think almost everybody did, which was with the order being published online. So it was quite the surprise for us.
And Mr. Bradford, just a follow-up question. When you say clear the site, so they won't have access to it to remove their, their personal property. Help me grasp this. Is it just that time is of the essence in these types of acquisitions for you guys to get on there and get your equipment up and mining, or if you can elaborate on a sense of urgency and define that?
Yeah, absolutely. So our intention was to bring in equipment. We have our own servers. We have our own infrastructure we were intending to bring in. The existing party that has it, Mine One, they have their own equipment and property on there. And so it was always the intention for them to move it out. We were going to give them a 45-day window, which was going to start immediately. Time is always of the essence in anything business. The sooner we're up and operating, the better it is for us on our side. But they are blocked from accessing it. They can access the property on specific, our understanding, I should say, is they can't access it for specifically following through on the transaction and clearing the site. But we are left in our interactions with them with a lot of questions about how quickly that they're actually going to be able to accomplish that.
Thank you for elaborating on that. Another follow-up question is, I know you run a Bitcoin mining company, you're not an expert on CFIUS, but have you gotten any indication of, in the event that they can't remove that kind of stuff, does that come with the acquisition, or how does that get handled? Or do they have the ability to sell that personal property as well? Or what does that look like going forward for you?
I don't know for sure. We wouldn't be able to comment on it. We could potentially have an interest in acquiring it. It hasn't been contemplated because really everything's kind of on hold right now. But I do believe our reading of it is that the federal government could step in and sell some of that personal property if it was not removed.
And my last follow-up question, I apologize for, this is actually kind of interesting and learning how CFIUS works. If that 120-day mark comes and, a deal hasn't been formalized, the price hasn't been agreed upon, any of that kind of stuff, title hasn't been, transferred and all that, what recourse or what ability can CFIUS come in and say, hey, since you guys can't do it, we have the authority to come in and say, you know what, we're going to sell it at a price they get to determine on the terms that CFIUS determines. Is that how that gets handled? Or do you have any indication of that?
We believe at the end of 120 days that could happen. Now we're of course a willing buyer that predated this. So our hope and intention would be that obviously this gets approved and passed through. Our reading for CFIUS is that their jurisdiction really relates to ownership and foreign investment. We're of course a US based company with US employees and US shareholders. And so we see no reason that CFIUS would prohibit us from proceeding through for any reason that they would actually have jurisdiction over.
Thank you, Mr. Bradford, for that clarification. Again, is there any questions for Mr. Bradford from the committee members online? I don't know if I'm seeing any. Mr. Co-Chairman?
Good.
No. Well, Mr. Bradford, we really appreciate you zooming in and kind of elaborating on your perspective on this. Again, I want to reemphasize that your business in Wyoming is really important to us. We want you to be successful, and we really appreciate you investing, your money in our state. And we certainly like to think of ourselves as pro-business, and this committee is, we are willing and able to help in any way that you need. So do not hesitate to reach out.
Thank you.
With that, committee members, is there anybody else in the room that wants to testify before we go online? Seeing none, who do we have? Looks like we've got Mr. Murphy. All right, we see.
Hello, Mr. Chairman.
Can you hear us?
I can hear you. Can you hear me?
Yep. You know the rules. Please introduce yourself, who you're with, all that stuff.
Yes. Good afternoon, Mr. Chairman and members of the committee. My name is Sean Murphy. I'm with BCB Cheyenne, also known as Bison Blockchain. The committee knows who I am. Everyone in Wyoming knows who we are as the ones who originally won this power agreement. And my comments are brief. They're very positive. At a high level, they're very supportive of CleanSpark. We see a company like CleanSpark coming to Wyoming being very positive. We know who they are. We know they're reputable operators. And one of our mining partners sold a large site to CleanSpark and has spoke very highly of them and their business practices. CleanSpark coming to Wyoming is good for many stakeholders. It's good for Black Hills. It's good for the Bitcoin mining industry, the network. It's good for members of this committee, just the general Wyoming brand, and holds a lot of promise for Laramie County. That said, I want to alert the committee to one important thing that's going on. In this transaction, the money is being paid to the parties that are on that presidential order. We have taken legal action to hold that money with the court pending the outcome of our lawsuit against all of those parties that are named in the presidential order. Many of you are familiar with this backstory. It was a part of SF 102, a bill that passed the Senate, but ended up not going through the Appropriations Committee with Senator Nicholas. So with all of that as the background, the last thing that I want to say is that I'm urging support for American Bitcoin mining on this committee. Those that are representing or helping Chinese Bitcoin miners, I think what's going to happen is you're going to be tried in the public court of opinion or the court of private opinion. So this is a great chance for us to all rally, the members of this committee, those in the state, company, and the team at CleanSpark for American Bitcoin mining. We really have a great opportunity in front of us, and I really urge the committee to think about how this is a win for so many groups in Wyoming, for CleanSpark coming in, but at the same time to keep in mind there are little Bitcoin miners, American Bitcoiners like us involved, and we're just asking that the money in the transaction be held with the court pending the outcome of this lawsuit. Thank you all for listening, and I really appreciate your attention on these big, actually historic matters in terms of a presidential CFIUS order.
Thank you, Mr. Murphy. Committee, any questions for Mr. Murphy? Seeing none, we appreciate your time, and we're certainly in agreement that we want American miners and to create jobs right here in Wyoming and across the nation. So we certainly keep our fingers crossed and remain hopeful on this one. So thank you for your time and for your testimony.
Thank you, Mr. Chairman.
I don't think, is there anybody else online? Anybody? All right, well, with that, public comment is closed. I think that we've pretty much covered all the ground we can. Mr. Co-Chairman, am I missing anything on this topic before we move on?
No, Mr. Chairman, I think we just needed the report on it to understand what was going on. And obviously we'll try and stay apprised of it. We'll keep watching the circumstances. We'll check in with Senator Lummis's office, and if there's anything we can do, we'll be there to do it.
Yeah. Mr. Co-Chairman, I wholeheartedly agree. I certainly think it's kind of nice and certainly maybe perhaps fortuitous that are lucky that it was an American mining company that was trying to purchase them in the first place. So I feel like this could have turned out a lot worse than it did. So it certainly sounds like it's going to land on its feet and be good for Wyoming and keep the mining going. Mr. Co-Chairman?
The one other thing I would say, though, is while there was concern with that particular site location for a Chinese mining operation, I think it's important for us to note that we do embrace, international investment. We do embrace other mining opportunities looking around the state of Wyoming. And I think there was a unique set of circumstances for that particular site that led to this type of action, but that should not hopefully be discouraging. As you noted earlier, we did really work to recruit and cultivate investment in Bitcoin mining when they were shut out of China back when they turned off cryptocurrency mining, and we're establishing a welcoming and hospitable environment for those miners to look at Wyoming and look at the resources that we have. I think that is a unique location, a unique situation, and I'm glad to see that CleanSpark looks to be able to work through that, because they will not have any challenges from CFIUS, but it is the proximity to the base and some other interests that create that unique circumstance that I don't want anyone left with the opinion that the rest of the state would in any way be in the same type of circumstance. So we want to make sure that it's clear that we're open for business to everyone in the state of Wyoming, and that we're not trying to discriminate or keep out folks from any particular country, any particular background, any particular interest. So Wyoming's open for business.
Yeah, Mr. Co-Chairman, I think you hit the nail on the head. I mean, I have to get fact checked on this, but I think there's roughly $1 trillion a year in direct foreign investment to the United States, which is great. On the whole, that's outstanding. It sends we are the destination for global investment dollars, which is, I think that's awesome. I do think it's absolutely appropriate, though, to monitor some of those dollars, and especially ones from countries that don't share our values, that don't have a system of governance where there is consent to the governed, where they have the First Amendment rights, all that kind of stuff. Not saying we shouldn't do business with China or with any of these other types of governments, because they're absolutely legitimate businesses to be that are out there doing legitimate business. But we absolutely have to keep a watchful eye on these types of things. And F.E. Warren is strategically important, and some of the nuclear missile silos that they interact with are really important. And so I think we weed out the bad actors, and I'm not going to go so far as to praise the federal government, but I think that this was the recourse that was necessary.
Mr. Chairman.
Mr. Co-Chairman, please.
And just one other note, it's my understanding that the appropriate process wasn't followed initially in terms of checking in with CFIUS on this particular foreign investment. Had that been done by the original organizers as the investment was coming in, we wouldn't be in this situation right now. So I guess I would just call out the importance of due diligence. If that organization had cited elsewhere, there wouldn't have been a problem. If they had gone through the full process, that wouldn't have been a problem. So I don't think we need to spend time trying to find ways to assign blame, but I think we need to look forward at this point and recognize that we should just be more cautious in the future, and recognize that this happened one time. Let's not let it happen again. And if we find ourselves in a circumstance where we have concerns about foreign investment, just go through the process. Make sure you're checking in with the committee. There's a process in place. File through that, and if concerns are raised, you'll hear about it before you have to be divested of assets. Just pick a new site. Probably would have been the answer in that circumstance. But here we are, and I think we have a good outcome on the horizon. So we're good here.
Mr. Co-Chair, I wholeheartedly agree. And I think that's part of the reason that we put this on the agenda, was to put a clear marker in the sand that, look, bad actors need not apply, but to the folks who want to engage in legitimate business and invest in our communities, we absolutely want them here. And I really appreciate CleanSpark coming in and sharing their perspective on this.
Absolutely.
With that, we're just about at the end of our agenda. Of course, now we've got committee directives. I know we covered a lot of ground today. Let's just kind of start from the top of our agenda.
General public comment,
Are
I
you-
don't think we do, but let's check in.
Yeah, doesn't look like it. Anybody? Yeah,
Yeah.
yeah, please do. So just in terms of protocol for testifying, just introduce yourself, your name, who you're here with, and share what you got.
Pardon me, I'm from Canada, Chairman, Select Committee, thanks for having me up here.
Yeah, we got, push the button. Yeah, until it's
Sorry.
green. There
Yeah.
you go.
My name's
Okay.
Chris Fernandez. I'm the CEO of a company called Block Gemini.
So Chris Ransom?
Christopher Fernandez.
Oh, Chris
Yeah.
Fernandez.
Nice. Actually was invited by Steve and Caitlin here earlier, but what we do is more work with the UAE government. We launched a stable coin over there. It's a $500 million backed stable coin. We've also launched the mining. It's a 1 gigawatt solo mining pool that we've created, and we have it's the UAE government mining, and then we also have built the national crypto exchange, the only regulated crypto exchange called M2. So today I'm in the state of Wyoming, all the way from Dubai to invest over here. And I'm very happy, very pleased. I actually just wanted to, I don't have any questions. I just have some praise to thank you guys for working with the most innovative technologies, bringing them and regulating them, and you can see the challenges that you guys are having. So it's a pleasure to be in this room. And, you know, I'm planning on, I've already opened a company here and establishing in the University of Wyoming in Laramie. So we're gonna do some projects out here. So thanks for setting this whole platform up. There was no other state for my group, which we have 250 employees, 6 offices, for us to look for a US base. So, you know, we have our European base in Luxembourg, but it's great to know that this is going to be home for us. So thanks for that, and being so welcoming and putting the laws forward.
Yeah, thank you, Mr. Fernandez. If you wouldn't mind, maybe elaborate a little bit on your mining operation. So you guys are using a gig?
Yeah.
Power, did I hear that correctly?
Yeah. In fact, not many people are aware of that 10% of the Bitcoin hash rate is actually being done out of UAE. So there's a publicly traded company that our company won 3 contracts from back in 2022. We delivered last year in May. It's called Phoenix Electronics. It's just at their IPO in December. So they awarded us some very hallmark contracts to. They were actually sending all their hash rate to AntPool, which is the Chinese pool, and I think there's a couple of reasons. One was to control their own hash rate. 2, to watermark their blocks. So every time they mine a block, they put their watermark on it. And in addition to that, they pay 2 to 3% fees, perhaps more if they're not watching closely to these pools. So these pools are not anyone could set up these pools. You must have a certain amount of hash rate to do so. And this group is already mining in several cities across the globe. Actually, just spoke to them. So if there's somebody that I could talk to after this about setting up a facility here, that's also through the government over there. They're interested. That same entity is owned by IHC. IHC is the sovereign wealth fund chaired by Sheikh Tahnoon, who's number 3 in the country. And managing over $25 billion in assets on the stock exchange as well. Yeah, we do have a regulated CBDC platform. I missed that part earlier today. And the goal, you know, it's up and running, and where the goal is to see if we can collaborate out here. Yeah.
Mr. Fernandez, a little follow-up. So using a gig of power, that's a lot of juice. I mean, how is that? Yeah, maybe if you wouldn't.
Yeah, you know, we had
tell me a little bit
challenges.
more about the nature of your agreement.
Well, we're a software development house, and we perform a lot of the digital transformation for Vodafone procurement using blockchain. So we don't have any coin, we don't have our own blockchain. We simply come into organizations and try to work with emerging technologies. The challenge for us there, when we signed that contract, we said up to 5 exahash. We ran the code, the server was running fine, up to 5 exahash, we were solo mining. But as soon as we went above that, it started, you know, so see some of the challenges we have technically with handling that many miners connecting to one pool. Yeah, I mean, I think Phoenix has done quite well for themselves. They're one of the top 3 miners in the world. And they started up with immersion cooling as well. It's in the desert, right in the middle of the desert. I think if I may comment also, some of the benefits to the state of Wyoming by doing this is your sort of energy infrastructure, right? The reason why they were able to do this is because the Americans installed a huge nuclear facility in Abu Dhabi, and they factor power for 25 years to come. So they had all that excess power that is for the future. So they were able to sort of recoup a lot of their investment on their nuclear as well.
And so,
Yeah.
Fernandez, it sounds like nuclear power is your main source for all that electricity?
Well, we're not in the mining business. We're in the software development business. We simply we built the exchange, we built the stable coin, and we built the mining pool for Solo. So we're not necessarily in the mining game, but through our network there, I'm sort of representing a lot of my clients, and they know I'm here and they want to invest. Yeah.
Mr. Co-Chairman, please.
So you mentioned you had a few projects. My apologies.
Yeah.
You mentioned you had a few projects in Wyoming. Tell us a little bit about what you're looking at here.
Yeah, in all honesty, I've been talking to Steve and Caitlin for the past 6 months. I was actually introduced to them regarding something related to mining. And then from there, they were telling me about some of the stuff that they're doing, and the stablecoin came up, and I said, hey, I just did this for the UAE. Let me share my screen and demo. And then from there, we struck a chord, and I thought about planning to make a donation to the university, specifically because they have a blockchain wing. I don't really consider it a donation. I consider it an investment. And then just having a few of my team members from Dubai fly in and work closely. We do a lot of stuff with supply chain. We also have a ride sharing app that we've built and different things. And United States seems to be the next step for us, and Wyoming is the perfect home.
Excellent. Are you going to be headquartered here or down in Laramie? What are your thoughts?
I think we just did an application online to create the LLC right now. And then most likely, wherever Steve recommends, I'll probably be going up there.
You should, yeah. He'll end up being. I shouldn't predispose you because he'll be biased towards where I want you to go. But look around the state a little bit.
Yeah. Well, I come with my mom and some of my family from California, so it's actually great for family. So I have a big family, so I plan on buying a house and enjoying this
Wonderful.
part of the world. Yeah.
Glad to hear
Well,
that.
thanks for having me up here.
Welcome.
Yeah, thank you.
Very glad to have you. Thank you.
Glad you're here. Thank you so much, Mr. Fernandez. Any other further public general comment? Seeing anybody online? All right, let's go ahead and close public comment. So last but not least, try to rack our brains and remember everything we talked about today. In terms of committee directives and staff directives, the big ones, let's just kind of go chronologically here. We had obviously a lot of chatter around speedies. We've got the amendments in the bill draft. Mitch Hopkinson, did you need any more clarification on those amendments for the next meeting, or?
Mr. Chairman, not for the speedy bill, I think. we're good
Okay.
there.
And then the other one was, in terms of directive, was the adding a agenda item, the promote, educate, and collaborate concept that was
marketing.
Yeah, one of the marketing themes that we can try to bring in the business council, the governor's office, some of those folks. Obviously I know, Senator Rothfuss and I, we'll pick up the phone and call anybody and sing their praises, but obviously more coordination would be nice, because God forbid, I think we're on 5 or 6 working groups across our committee.
Yeah,
Minerals,
plenty.
this one. Yeah.
Mhm.
Yeah.
Mr. Chairman, on that though,
Co-Chair, go for it.
one suggestion on the outreach that I think is a very thoughtful suggestion from prior conversations was the idea of putting together a little group to actually travel out to the West Coast and sit down with a dozen or so venture capital companies that deal in this space and just talk to them about, this is what Wyoming has put together. This is what we have. You might be interested, because we're well known in many circles, but we're not well known in all circles. And that's a circle that we need a better presence, because it's a limited group. So obviously we have folks with our colleagues at A16Z and other places that know about us, but maybe growing that universe and even working with them to try and help facilitate that might be helpful. So that's one concept that has been tossed around a little bit. This might be the year to actually do that. And there might be other places that we can go and have similar conversations. But I think one of the interests there was for us to really identify an individual or put something together, maybe through the Wyoming Business Council, where we always had a presence at the major get-togethers around the country that are related to digital assets, and that there was always somebody there saying howdy and this is what we're up to in
Yeah.
Wyoming.
Absolutely.
And we don't have that. We have great people that show up from time to time, but we don't have that central presence that's always out there.
Yeah. I think that's a really good call. It's the end of the day, if you're not out there promoting yourselves.
Yeah.
Yeah. One of the things obviously we covered, or some of the discussion, and I'm certainly comfortable with maybe moving forward the draft, was reinstating some of that language on the requirements of the Attorney General that was in the initial draft of our Speedy Bank charter bill. Mr. Co-Chair, what are your thoughts on including something like that?
So on that topic, I think there's two ideas that we tossed around, and one, Leader Yin was talking about the idea of getting a bill on master accounts and putting that together, and I think that's a standalone bill by itself.
Yeah.
So we need to talk through the idea of whether we want the treasurer, a bank, or a trust to be the vehicle for the master account.
Or the stable token.
Well, stable token would feed into any of those.
Commission, excuse me,
Right.
rather.
I don't think we'd want the commission to act in that capacity, honestly. The commission has the authority to use any of those three things if we created it to operate, and they would need to. So but I think that's a consideration, is making sure that whatever we create works well with the
Yeah.
stable token commission. So there's some conversation there. It would be relatively easy and straightforward for the treasurer. And then it adds a little more complexity with the trust, and then a little bit more complexity with the bank. And so that's a conversation, but getting that legislation drafted for the next committee, to provide that directive, is something we should contemplate.
Yeah, well,
And then the other issue
Attorney
is,
General, yeah,
that's a separate bill, and
Yeah,
I think
so-
it should be a bill, and I was gonna talk about that separately.
Let's just, my thought, Mr. Co-Chairman, is that we make the master account just a topic of discussion, do a bill draft request, and have that teed up for our last meeting in September in Laramie. I mean, I think otherwise we could be potentially looking at multiple bill drafts, right? One for each of the concepts, a bank, a trust, and then of course the treasurer's office and some of the other ideas that have been thrown around. So
I think
or Representative Yen, go ahead.
Mr. Chairman, thank you. Maybe I think the best course of action is that Ms. Long mentioned that there are 10 different states, and so I assume that there are 10 different forms that each of those states take. So it might be worthwhile to have a memo from Ms. Nord on what those forms look like, and see how we can, at our Sheridan meeting, see how we can ask for a bill draft for our last meeting. For one of those forms, and how we could, and think about from now until then, how we could fit blockchain offering services to Speedies, defending our tiny local banks at the same time within that structure.
No, I think there's just a lot of ground to cover in however we want to approach that master accounts concept. So I think putting it as a topic, getting some of these memos prepared and giving us a better understanding so we can move forward with a good bill draft. I guess my worry is, for one, with staff moving forward with all these different drafts, if we can give you guys just one master account draft versus multiple, ideally that would be great. We'll have to see how the discussion goes and shared at our next meeting, but I think that would be certainly easier for you guys versus multiple. So without, Ms. Co-Chairman.
Yeah, I just add, and I agree, I think that's a good path for us to go. I would say that putting together a bill that directs the treasurer to obtain a master account with certain provisions is a short and easy bill. The other ones I don't think are gonna be as easy. But there's no reason for us not to contemplate it and explore that. It almost seems like the process of creating our own bank isn't a one session bill. If we went to the bank route, we might need a little while on that one. That would probably be a bill where we put something forward that began the process to figure out how to create a bank, work with the banking commission, figure out what that might look. Just that'd be some work. So
Yeah.
I think it's important to realize that. But the exploration as the next step, I think, is a great next step.
Ms. Kutcher, I think so. Mr. Hopkinson, do you have any sense of if that would be a pretty complicated bill draft, or would it be pretty straightforward?
Mr. Chairman, I don't know at this point. I'd have to do some initial digging to see what it would take to actually get the master account. I don't know.
How does this sound? Maybe if we proceed with just kind of an initial request and have you look into it, if you think it can be something that's pretty straightforward, let's see if we can get a bill draft for it, but if you quickly realize it's more in depth, we can put it as a topic.
I
Or
like that.
yeah, I mean,
Yeah, we do both. We get a memo anyway.
sometimes we march David down some,
Yeah,
send him on some pretty scary journeys, so
yeah.
we don't overload him too much, but Mr. Hopkinson, is that workable for you? Okay, and just obviously stay in touch with the co-chair and I on if you start encountering some pretty serious obstacles, but conceptually, let's move forward with the bill draft just for the treasurer's office, and we can put the other options on the agenda. In terms of, I think it's worth discussion in our next meeting, and I guess the idea would be to have it as a topic about reinserting the language that was removed in the initial draft of our speedy enabling legislation that would require the Attorney General to pursue legal action if they're not granted a master account. Mr. Co-Chairman, please.
Yeah. Mr. Chairman, I think on this one, a broader bill where we explore where we put this in statute, but look for the capacity to defend the two-tier banking system on behalf of Wyoming in a broader capacity than simply the Speedy Bank bill would be preferable. And as a Section 1, put language that positions us to have standing. So basically, a clarification that the state of Wyoming has an interest in protecting the two-tiered banking system, and that we are responsible and that the state will take action to support and defend the two-tiered banking system. So language to help us to create standing in a federal setting. And then in the second section, basically say that the state may or shall, kind of figure out how to do that through the Attorney General's office, take action to defend the two-tiered banking system, and then lay out protect master accounts or acquire master accounts or ensure that our state chartered banks receive master accounts, FDIC issues, anything along those lines. So a to include but not limited list that maybe we can check with the banking commissioner on what those types of actions might be. But again, to make it broader so that anytime we have a circumstance where the feds are favoring national banks over state chartered banks, that the state needs to step up and defend our banks, and that it's not just up to the banks, that the state should have standing and should take action. I think that broader writ is kind of important because while we have one case before us that we clearly want to be involved in, it may not be the end. And, challenging Federal Reserve decisions, those types of things as they relate to our two-tier banking system. So that would be my suggestion. Still not a long bill, but rather than going directly into statute and making that tweak, I think it's important for us to broaden it and say that we're going to defend the two-tier banking system as a state. We're going to use the AG's office to do so.
Mr. Hopkinson, do you have, or maybe Mr. Co-Chairman, do we have a copy of the language that was removed back in, that would have been December of 18, I think, give or take?
It's in that ballpark, yeah.
We can certainly get it.
Okay. All right. Yeah, let's go ahead and move the conceptual bill draft along those lines. Again, it doesn't have to modify the original act, but certainly just finding an appropriate place for that. Do you have any questions or clarifications that you need, Mr. Hopkinson?
Mr. Chairman, as long as I'm clear to work with the division, I think we can put something
Yeah.
together.
Of course, absolutely.
And Mr. Hopkinson, does that make sense? So the first part, establish standing to the best degree we can. Second part, say that based on that, we're going to defend the two-tier banking system through the Attorney General's office and with the cooperation of Division of Banking, whatever else, to ensure that we're protecting our access to master account numbers, FDIC insurance, anything else we need.
So is there any objection to moving forward with a conceptual bill draft along these lines? Not seeing any. Excellent. Mr. Co-Chairman, I think that clears the deck, or is there any?
Mr. Chairman, where did we end up? I'm struggling to remember whether we took action on it or not, on the exploring reciprocity marketing solutions. I
Yeah.
think we kicked that until after lunch and then didn't end up taking any action because we came right back and worked on other issues. Am I remembering that correctly, or did we make a request, David?
Mr. Chairman, there wasn't a request. The way I understood it was you kind of kicked it back to them to
Yeah.
come back with a
Follow-up
little bit more
research.
specific.
That's right.
Yeah,
That's-
Mr. Co-Chairman, I think I asked Albert to, Mr. Faulkner, if he could do some digging and if there's any consensus on what they really want amongst
Yeah,
what specific reciprocity components. And so I thought is let's just kind of stay in touch on that one. If there's consensus, there are some things that they think could help them. We can put that as an agenda item, but in the event that we don't, we can just let that one go. We've already kind of got a pretty full agenda, I think, for Sheridan.
I agree. I think that's a good approach.
Yeah.
Yep.
I think with that, members, anything else?
Oh, that's
All
plenty.
right, that clears the deck. We are adjourned. Thank you so
Awesome.
much.
Thanks, everyone. Appreciate all of your participation.